All right, so what I'm going to do is I'm going to share my screen and we're going to go through the PowerPoint. The other thing too is that if you'd like a copy of this PowerPoint, my email address, I have it at the end slide. You can email me and I'd be happy to send you a copy of the PowerPoint. And feel free to share that with any other board members too. All right, so board member certification. We're going to get going here. So some of the topics and objectives, we're going to be talking about operations, elections, financial issues, and then official records. The objective, we want to increase the knowledge and duties and obligations and the applicable Florida statutes, define the role of the board, the legal obligations as a board member, association protection, and then association problems and issues. All right. So going into operations, and this is, operations typically takes about our first half because there's a lot to address here. So I'm going to be going through a lot of different things, but I think it'll help you all go through all the different items that we're going to be dealing with. The first thing is governing documents. What are your governing documents? The governing documents for your community association, they typically include these several items in descending order of authority. So what I have these listed are in their order of priority. So you have your declaration. I have that listed pretty generally, but it's your declaration of condominium for condos, your declaration of covenants and restrictions for HOAs. If you're in a co-op, you have a little bit different set of documents than that. But typically it's going to be your covenants, your use restrictions, that's going to contain what am I allowed to do with my property and so on. That's pretty simplistic, but that's where you find what am I allowed to do, what easements are in place, what use rights do I have, that sort of thing. The Articles of Incorporation, that is what establishes your association as a corporation not-for-profit with the state. If you go to, in Florida, it's sunbiz.org, sunbiz.org. You can go and search the official records. And you can search for your association. And depending how old your community is, if I believe it's from 1995 or more recently, you'll see your Articles of Incorporation file there. That's what sets you up as a corporation. It typically contains what the purposes of the association are, the corporation, what powers the association has. They may establish the number of directors, but for the most part, it's more corporate procedure and certain powers that are afforded to the board of directors and to the association. Kind of similarly, the bylaws kind of flow with the Articles of Incorporation as well. The bylaws are more of a procedural, how does the board operate, and the meeting requirements for the members in terms of the quorum requirements, the notice requirements for your board meetings, your membership meetings, your election process, that typically will be contained in your bylaws. So if you're newer to an association, you haven't served on the board before, a lot of times you hear it, they'll say, well, our bylaws don't allow us to do this. But what you actually might be talking about are really on your declaration and your covenants, because that is what contains your use restrictions, whether or not you're allowed to have basketball hoops, or if you have rental restrictions, that's going to be typically contained in your declaration. Then you have the rules and regulations. Those are typically authorized in the declaration, perhaps in the bylaws as well, that the board can adopt rules and regulations further regarding common area use or parcel use. It is important to note, though, don't just assume that you can pass rules for parcels or for units by default. There's no statutory mechanism that allows you to do that. You actually have to have that authority in your governing documents. And you'll typically find, though, in probably 95% of the governing documents that we look at, it will say something to the effect of the board shall further have the authority to promulgate rules and regulations regarding unit and parcel use or common area use, something along those lines. But your rulemaking authority is subject to the authorization that you have in one of the higher priority governing documents. So I think it's important to note that. Actually, I want to go back to, also as part of the rules and regulations, I also would lump in your architectural guidelines. So if you have any architectural criteria, guidelines, again, those have to be authorized. And this typically more is for our HOAs in here, our HOA members. Where you have more architectural standards that may be in place for modifications to the exterior or new construction. That typically is going to be contained in your architectural guidelines, but you have to have authority in a higher priority document like your declaration to establish those guidelines. So again, be mindful of that too. So some of the things the association must do. The association must establish a budget. That's going to be your roadmap for what your budgeted expenses are for the year, how you're going to derive your income. You want to set aside funds for future maintenance, collect assessments to pay for the common expenses, and then enforce your rules and regulations. Now, when I say you must enforce your rules and regulations, there actually can get into a little bit of a, I don't want to say a gray area here, but it comes in, there's a lot of interpretation involved. It's not always going to be black and white. And I'll tell you that when I'm contacted as an attorney, I always like to say, if it was black and white, you wouldn't need to be contacting me in the first place, right? And so there is some interpretation as to, is this a violation or not? Is this something that we need to do as a board, or is it something that the parcel or the unit owner is allowed to do? We need to take a look at that. The main thing that I always like to stress upon board members when you're looking to enforce your rules and regulations, your governing documents, your covenants and restrictions, is that the default rule for property ownership is that owners should be able to do what they want with their property. That's kind of a general, basic property law that you have. In order to enforce any type of restriction against them, it's going to be construed against the party that's looking to enforce that. And so what you want to do is make sure that you have a clear basis for enforcing whatever the restriction is, or the rule that you've enforced. And so if it's vague, I'm going to come back to the board and say, look, it looks like you're trying to require them to pressure wash their driveway once a year, but you're doing that through a pretty vague provision in the documents that says that owners must keep their property in a neat and clean condition. Well, it could be argued, one person might say that you need to pressure wash it once a year. One person might say you don't actually need to do it as long as they do something else and it looks neat and clean. So if you want to have that as a specific requirement, you should pass that as a specific rule, because otherwise, if it's not as specific, you may have a trouble enforcing it later on as an association. That's one that I see a lot. It comes down to, or the other thing that comes up, especially from the condominium context, or maybe from a co-op, or depending on, usually when you're living in tighter quarters, and for townhomes too, is, there shall be no nuisance. And so if somebody's making a lot of noise, it can be subjective in terms of what may be a nuisance to one person may not be a nuisance to others. And so there is some fact finding that's involved for the association to determine, hey, is this something that we need to enforce? It is the board's discretion. I think what you'll find, especially for new board members, and if you're an existing board member, you may be nodding along with this. You may get owners that complain to you saying, hey, my neighbor's doing this, why aren't you enforcing this? And you as a board may say, I don't think this is a violation. I think that you may have a little bit higher sensitivity than what maybe constitutes a violation of our documents. And so we're deciding as a board not to take action. Just because somebody complains doesn't mean that it's necessarily a violation. You as the board have an obligation to kind of look through that, determine the facts, and then see if it's something that you should move forward on or not. So some of the board responsibilities and what to know. The board responsibilities are to protect and ensure the interests of the association at large. You need to avoid personal gains. I'm going to be touching on that a couple of times throughout this, avoiding personal gains. And the same thing with acting fairly and equally to all members. So you want to maintain your common area interests, of course, and then you want to enhance, really promote rather than diminish all the common area interests. So the big thing that I like to state, especially right now, we're in July, we're in hurricane season right now. I believe I have it on the next slide here. So I have condo insurance, but really this applies for HOAs and for co-ops as well. Anything that the association insures, you need to make sure that it's properly insured. I'm going to go back on this slide first. Think of your community as, if you have 100 homes in your community that are each worth $300,000 or something like that, you have a $30 million asset that you're essentially maintaining as an association. And remember that you're running this as a business. You're a corporation, not for profit. You're not being paid to serve on your board, but you are running a business. It's a corporation. And you have to think about that you're protecting the asset, which is the homes, the value of the homes in the community. And so when you look at that, one of the biggest things that's going to be in your budget is insurance. Cost, the premiums for your insurance, that you're properly insuring the common areas, that and anything else, that you have a general liability policy, and also your directors and officers liability policy. For all of you, you're not getting paid, you're serving as volunteers. Make sure that you have proper standards for D&O coverage. Talk to your insurance agent to make sure that you're properly insured, because while it's very difficult to be sued as a board member, successfully in terms of if there's an ultimate judgment against you, it's very difficult to obtain that. It doesn't mean that somebody could still try to do that in an effort to achieve some type of settlement, or if there's insurance involved, to receive some type of payout in order to resolve the dispute. So you want to make sure that you're protected as board members, so that you know that there's going to be defense provided to you and that you're not having to pay it individually, and that the board really isn't having to pay it either, because it really should be paid out from your insurance policy. So make sure that you're properly insured. Right now, if you look to your policies, you still have, we don't have a storm that's necessarily bearing down on us. I know there's one in the Caribbean, and I don't know that that's going to come up. We're all, storm forecasters this time of year, but talk with your agent. If you're not sure if you're properly covered or if you need to increase your coverage limits, you are able to do it, but there is a certain waiting period depending on if there's a storm that's within kind of the zone there that's close enough to you. So talk to them about it. It's not too late necessarily. Just make sure that you're properly insured. So going into the next slide then, really for any of the associations in here that have common areas or property that's being insured, the main thing we want to look at, if you look on the left-hand side, is you want to make sure that you have law and ordinance to policy limits. What that means is that if you have especially an older community or older structure, your community, your building may have been built to a different standard, the building code at the time, and that if something were to happen, if you don't have law and ordinance to policy limits, you may not be getting the money to bring it back up to code. It's what's required right now. So you want to make sure that you have law and ordinance to policy limits. You want to make sure that you have a wind-driven rain endorsement. That's pretty much a given, but again, talk to your insurance agent about it. You want to have proper coverage of all structures, including your signs, light posts, dog houses. Everything should be scheduled. The next thing is regarding a co-insurance penalty. What that really is that if you do have a claim, and if it's found that you listed as the value that was being insured maybe an $800,000 structure, but it's really $1 million structure, they're going to state that you underreported it by 20%. I'm kind of simplifying it, but essentially you've underreported it by 20%. So that if there is a value, a claim that's actually brought, they're going to look at it and say, well, you would have received this, but the co-insurance penalty or co-insurance is 20% because it was underinsured essentially. So make sure that you're properly listing the value of the structures that you're insuring, so that if there is a claim later, you're not harmed later. The increase in premium is going to be well offset by the increase that you're going to get if there's a claim on it later on. And then make sure that you have replacement costs and everything. You don't want to have it so that it's just actual cash value, because what's going to happen is that's taking out if there's depreciation. You want to have replacement costs. What's it actually going to cost to replace this, rather than what's the actual value of what is being replaced, if that makes sense. So make sure you have replacement costs and everything. The other thing too is I taught a webinar last month on this. You have to bring insurance claims within 3 years. I bring this up because in Northeast Florida, most of you are probably in here in Northeast Florida, you had Hurricane Irma that came in through, I believe, I always get Hurricane Irma and Matthew mixed up. I believe Irma was in September of 2017. We're coming up, well, we're within 2 months of that. And so if you're unsure, you need to look at it immediately if you have roof damage or any other type of property damage that may have been caused by Hurricane Irma. And if you haven't placed a carrier on notice already, you need to look at it immediately, because you're going to be outside of your time period to bring the claim within a couple of months. The other thing on the other side here is for construction defects. This is for mostly what I look at is for condominium associations or townhomes, but also if you're an older community that maybe had a restoration project done, you're able to bring a construction defect claim. There's a certain time period for it. You have 4 years. It's called statute of limitations from when you knew or should have known that there was an issue. So if you see a whole bunch of cracks in the stucco and you investigated it and saw that there was water intrusion coming in, you're probably placed on notice that you need to bring a claim within 4 years. However, if it's something that's latent, and most construction defects are hidden, they're latent defects that you can't actually tell, you actually have up to 10 years to bring a claim, but that's kind of the drop dead date. Doesn't matter when you become aware of it. The 10 years runs from, essentially for new construction, it's when the contract is completed or when the certificate of occupancy is issued. For the restoration projects, it's typically upon the completion of the project. You have no more than 10 years to bring the claim. But again, you may have to bring it earlier than that if you became aware of an issue under the statute of limitations. So make sure that you're looking at that. If you're unsure, our law firm, we represent a number of community associations. We actually have over 30 associations that we work with that have construction defect issues, that we're able to look at that at no cost to take a look at the applicable time periods. And we also work with engineers that can take a look at your property. So if you're unsure, reach out to us. We're happy to help you with it. We just don't want you to miss out on being able to bring a claim against the responsible party that caused the problems, rather than it becoming a maintenance issue that all of a sudden now all the homeowners are having to pay for because of the fact that you have to raise your assessments to cover all the repair costs and everything. So we just don't want you to have to do that if there's a party or parties that you can go after that was responsible for the damage. So the board responsibilities, you're required to act as one unit to set policy. You know, you're able to have differences of opinion, but what you want to do is go through it, have a proper motion made, a seconded motion, have a discussion on it, have a debate, and then vote on it. And if it's something that's been carried out, you want to act as one unit to carry out that policy. You're enforcing your governing documents, maintaining the value of the property. We talked about that in terms of from an insurable standpoint, but also the whole reason why you have your HOA, or big reason why you have your HOA and your condo association, is to govern the use of common areas and facilities, but also for the value of the property by maintaining those amenities, the aesthetics of the community, making sure that architectural standards are in place. That's a big function of what the association does. You're conducting board and annual meetings. That's a way to make sure that you're meeting at least frequently as a board so that members can participate and see what decisions, how the board is making their decisions. You want to set goals for the association and then maintain the association's financial stability. So then the board's legal responsibilities. You have a fiduciary obligation, which is a duty to act for someone else's benefit and to act in the best interest of the association and its members. So when you have a fiduciary obligation, that's one of the highest obligations, a duty that's required by law. So you have a duty to act with good faith, diligence, care, and skill. The main thing that I mentioned to you as board members is you don't have to be perfect in your decision making. What you need to do, though, is act reasonably, rely upon professionals that you work with to think through problems that you have, think through the issues that you're facing, go out and get competitive bids, think critically about what you're going to be doing. And then as long as you go through that process and make what you feel is in the best decision, in the best interest of your association, you're going to be protected as board members and you've done your job. It doesn't mean you need to hire the perfect company, and if that company screws up, then the board screwed up. That's not the case. Just as long as you go through the process of at least how do you get there and hiring these people, and then if they're doing something wrong, you send them notification, you go find a new vendor or something like that. That's your main obligation as a board. You have a duty of loyalty to your corporation, duty of ordinary and reasonable care. That's what I just talked about in terms of your decision making, and then a duty of confidentiality during and after your term of service. So that's another thing too, is that when you're on your board, you have a duty of confidentiality, and there's a privilege there when you're talking with your attorney that when the board talks about something with the attorney, that needs to stay within that confidential discussion because it's privileged. And if you as a board member go out and start talking to the members about something that's privileged, you're deemed to have waived it for the entire association, so that now it opens up, if there's a lawsuit, they can ask questions of the board members because that attorney-client privilege has been waived. So you really need to make sure that you do that during and after your term of service. So anything that you learn as a board member, even if you're no longer on the board, you have a duty to keep that confidential. So some practical things here too. Building community. You want to become community involved. You want to seek a positive resolution to community and member issues. Emphasize reasonable living and respect. You want to create a healthy relationship with renters and establish committees. So briefly about renters, and I have a slide on it later when we talk about collections, but putting aside collections, you want to have a good relationship with your renters because they're going to be in there, and there's a stigma attached with renters that they don't care as much as the owners do that are living there. I think that a way to help them buy in is make them feel involved with the community. Now, it's harder right now with COVID, right? I would say maybe you have some social events where you invite the renters to come out. Obviously, that's not as practical right now, but another thing that you can do is when you know that there's a renter that's coming in, first thing is to make sure that you have a procedure in place so that the association's aware of new renters, and then you can send out a welcome packet. Maybe something that's nice, a nice letter that says, we're happy to have you in the community. We're really proud of our community. We like to be aware of some of our rules and regulations, and that's where you hand them the rules and regulations so that they're aware of, hey, this is what's expected of you, and I think that if we all can do this, we're going to have a nice place to live. And that way it gets around. Sometimes renters say, well, I wasn't aware that these rules and regulations were in place. The one thing I'm asked that frequently by board members, and what I say is that it's actually not the association's job to provide that and be proactive and find those tenants. It's actually the landlord's job, the owner's job to make them aware of it. I have some communities that have amended their documents to require that that be included as part of a lease. I'm not saying you necessarily have to do that, but what you could do is pass a rule that says that if you're renting, you need to notify us. That way you get their information and you can send them out a welcome packet like I mentioned there. The other thing that I have here is establishing committees. I think this is very helpful for you, especially for our new board members on here. It's going to seem daunting, maybe depending on the reason that you got on the board. Maybe you ran because you didn't like the way that the community was being run and that you have a lot of issues that you're trying to address. Establishing committees is really going to help you with that, because you're going to find that you have people in your community that have past experience or a certain area of expertise that maybe they don't have the time or the ability to run for the board, but that they want to help on a certain issue. And I think it's very helpful to send out basically a survey or something, or a call for volunteers and say, hey, if you have a certain area of expertise, we're thinking of these areas, maybe a finance committee, maybe a landscape committee. You could have a legal committee if you're having a legal issue in your community, and maybe you have some lawyers involved that can maybe help work with the board in some type of executive committee or something like that. You might have a covenants committee if you're looking at redoing your documents, and you might have some past presidents that have gone through this that aren't running for your board, but have gone through a covenant amendment process that want to help out. So established committees, they can help take some of the work off of you so that they can do some of the legwork provided to the board as a recommendation, and then you can decide whether or not to go along with that. And I think it just helps get more involved with your community and have members participate. One thing that I find is that homeowners complain that, well, why did the board do this? And they don't understand all the work that goes into being a board member. And so I say, hey, if you'd like to, we'd love to have you join a committee that you can work on that and then make a recommendation to the board so that we can evaluate it. You'll find if that person's really serious about making their community a better place by if they're willing to put the time in, or are they just showing up to complain at board meetings. So establish committees, draw on the people that have expertise, and also see if your complainers will actually be a doer for your community or if they're just going to be a complainer the whole time. So some of the responsibilities for the board is responsible for making decisions and setting policy. The board must reach a consensus on policy and direction. So the big thing, if you're looking on the left-hand side here, is the board is it makes the big picture policy decisions. If the board gets too involved in your meetings as to how that policy is going to be carried out, the board's getting too much in the weeds. That's where you need to defer to if you have a management company or your manager. Your manager is really tasked with taking the policy of the board and then carrying it out, making sure that policy and the directives are implemented. Same thing really going with the president too. The president typically and the manager work hand in hand to carry out the policies as set forth by the board. That's the main thing. If I can give you a recommendation, is try to keep your board meetings to an hour. If they're your more standard board meetings. If you're having too long of board meetings, it might be because you're either trying to tackle too much or you're trying to spend too much time on carrying forth the policies of the board during that meeting instead of letting your professionals and your elected president really do that on a day-to-day basis. Communication with management. I know we have managers on this, so I hope, and I've worked with a bunch of managers, and I always try to talk to them, and I'm interested in how their job works in terms of working with the board and some of the things that managers will tell me. And the main thing, and I'll speak for them too, is I just wish they would let us do our job sometimes. You've hired us, you're paying us to do this. Let us do our job for you. We've done this. This is our profession. Let us do this for you. And maybe some of our managers are nodding their head right now. I can't see you, but I think that some of you are doing it. So you want to make sure you have a shared vision between your board and your community manager. You want to agree on expectations. Obviously, that's a big thing to make sure that you're working in concert. You want to understand the difference between setting policy and directing operations. I just hit on that before. Having action lists and monthly reports, that's very helpful to make sure you're staying organized so you can look at, okay, well, what did we tackle this month? What do we still have left to get done? That's a way to keep, so when you have your board meetings, you can have an orderly thing and staying organized with it. And then obviously you want to work with mutual respect. That's the main thing. You need to have that in terms of having a good working relationship. Board member roles and responsibilities. As board members, you're homeowners elected to serve by your peers. You're responsible for the conduct of business and delivery of service to the association, subject to your governing documents and the applicable laws. This is one point where I'd like to stop and just briefly touch on what the governing laws are for community associations. So in Florida, I like to give this example. You may not tell, I'm from Wisconsin originally. My accent, I think, is still there a little bit. But when I moved down here, I had no idea that there was a difference. I thought everything, if there was an HOA, that it's an HOA. If you live in a community, you have documents, it's an HOA. Well, in reality, in Florida, you have a condo association, you have a cooperative association, you have a timeshare association, homeowners association, a mobile home park. So you have, I believe there's 5 different statutes under the real property section for the Florida statutes. That you have a different act for each different type of community association that you may live in. And so there's a lot of overlap between them, but there are some differences. And so for a condominium association, you're looking at Chapter 718 of the Florida statutes. For HOAs, you're looking at Chapter 720. For co-ops, it's Chapter 719. You have to look to those for the type of community that you're in, and they're going to cover a lot of what governs your community. But you also need to look at Chapter 617 of the Florida statutes. That's the Corporation Not-for-Profit Act. That's going to govern anything that maybe your governing documents and the specific state statute for your community may not cover. The thing that usually that I look at, and I always bring up as an example here, is a question might be, hey, are we allowed to take out a loan on behalf of our community? And maybe your documents may be silent as to that specifically. The HOA Act is silent as to that, but your governing documents might say that the association has all the powers of a corporation not-for-profit. Well, there's a provision in the Corporation Not-for-Profit Act that says under the list of association powers, one of them is to borrow money. So I would say, hey, you actually do have this authority, and it appears that it's done by board vote. So that's where you're kind of looking in between your governing documents, your specific statute, and then your Corporation Not-for-Profit Act. There's going to be other statutes that come into play when you're working with community associations. There's a towing statute. There's a statute regarding energy efficient of devices, like for clotheslines and that sort of thing, that's completely outside of the laws governing condos and HOAs, but still are going to be applicable to you. So that's where it's important to be working with your community association manager and really with your attorney to make sure, hey, am I allowed to do this? Is there a statute that governs this or not? All right, so some of the qualities of a good board member. And after this, I'm going to, let's see, I'll pause in a little bit. I know we've had some questions coming in. I'll try to take a break to see if I can address any questions for what we've talked about so far. So qualities of a good board member on the left-hand side, strong board member characteristics. You have good character, strong integrity, calm judgment, a willingness to serve, is committed to the best interests of the community as a whole, has some type of relevant experience or background, has previous volunteer service, has strong people skills. I can tell you that as a board member, as a manager, as a community association attorney, you have to have strong people skills, because it's everybody, it's your home, right? So you're living in a community, your home is in here. This is where, you know, you have an emotional stake a lot of times. And so people can get fired up at these meetings because it's their property. They're being told what they're allowed or not allowed to do with their property. You're also assessing them to carry out pay for the common expenses. So you're coming out of their pocketbook. People are going to get upset. Tempers are going to flare at times. You want to have good people skills to be able to talk with them and kind of work through certain issues. And then the last thing that's really important is you need to be a servant leader. And what that means is, as a board member, you need to be willing to do the work and show that you're willing to serve in the best interest of your community. That's what a good board member does. On the other hand, you have these characteristics that we find are most commonly involved with a weak board member, is unable to put the welfare of the community first, works behind the board to run things his or her way, is impulsive or quick-tempered, has a personal or hidden agenda, puts individual interests first, has little or no experience in management, leadership, or service, and is unable to work with others for the common good. Now, just because doesn't mean you're a bad board member if you have little or no experience. It just means that that's when you add that in with some of these other things, that's when you combine to have what I would call a bad board member. And you can see the common theme there is that they're working on their own agenda. They're not willing to work as a team. They're trying to push things. They work behind and try to politic behind the scenes to get votes on certain things. So that's what we try to work against, I guess. My partner Mike has given a good example. If you've attended one of these or if you've worked with Mike before, he said that when you look at bad board members, a lot of times they fall into two camps. Either the never had power syndrome, which means that they've never had power and maybe whatever profession they've been in or whatever else has been going on in their life. And so they run for the board because they want to feel that power. They want to be able to make decisions. And so that might not always come out the best way in terms of decisions that are being made. Or on the other hand, you have the loss of power syndrome, where somebody may have had a high power job. Maybe they were executive of their company and they retired and they missed that. So they wanted to feel that feeling of power again. So that's where you find a lot of the bad board members. They're coming on for the wrong reasons. So some of the roles and responsibilities: the president calls the meetings to order, announces the agenda and adheres to it, recognizes members entitled to the floor, states a question, calls a vote, announces outcomes, maintains order through impartial parliamentary procedure. Now, that's Robert's Rules of Order. Many of your documents may state that. You know, Robert's Rules of Order are typically meant especially for larger corporation, larger governing bodies. Sometimes it's impractical to stick to that, to the letter for community associations. The main thing is making sure that you have a uniform parliamentary procedure so that it shows that you have a specific process, that you're not seeming to favor one person over the other, or going out of order because you're pushing some type of agenda. The main thing is having a parliamentary procedure to run proper, orderly meetings. That's the main point. The other thing is the president does is they expedite business, is familiar with all the rules and documents of the association, and then appoints committees for bylaws. So the other thing I have on here, and I've talked about before, is the president is really the day-to-day officer. They carry out the functions of the board. So in other words, if the board has adopted in its budget a certain amount for maintenance throughout the year, right? You have common area maintenance. You don't have an ongoing contract for it, but if something comes up, you have money in the budget to cover it. The president can make the decision of, hey, we have a one-time expense of $750 to fix this. That's typically something that the president can authorize the manager to do, or even the manager might have authority in their contract to make a one-time expenditure up to a certain dollar amount. The board they don't really need to be involved on making a vote for that. Now, if it's an ongoing contract, for example, that's typically where the board gets involved and you want to talk through that and have a board vote on it. But your president is your day-to-day officer. I've worked with communities where they've stated that anything over $100 expenditure needs to have a board vote. You can imagine how crazy that would be and how many things would be on the agenda or how many board meetings you need to have for the things that may come up with your community if you had to have a board vote for everything like that. The other thing too, just with this for the president that I like to stress, is that the president and the manager really work in tandem to make sure that your meetings are run properly. What I find sometimes is that a good president will say, all right, we have this on the agenda. Does somebody want to introduce this? Okay. Are there any member comments? And then they recognize members entitled to speak from the floor. And then from there they say, okay, do we have a motion for this? Somebody makes a motion in a second. There's some discussion on it. And then what happens sometimes is the discussion can go on for a while and it can kind of veer off into different paths. And I've seen it where then somebody will make a motion and then really a good president will come in and say, well, hold on. We already have a motion that's on the floor that's being discussed right now. Do we have somebody who would like to amend that motion, or we need to vote on this motion first and then somebody can make a motion to go on to the second issue? That's how your board meetings can get off track and can take too long. A good president can really make sure that they're keeping things on the right path and that they're sticking to the agenda and what motion has been made and then voted on. Vice president has all the authorities of the president and when the president is absent. The secretary and the treasurer are the two things that when you have a manager or a management company, they're fulfilling most of these duties. But the secretary is the recording officer, the custodian of records. They keep accurate minutes of all meetings, and then they sign minutes and any other document for the most part. The treasurer keeps thorough and accurate financial records, produces regular reports of disbursement and income, produces annual financial reports to the membership, submits financial records for audits, and then authorizes the disbursement of funds. And then the manager, the responsibility of the manager, the scope of duties are specified by contractual agreement. The manager carries out the policies as set forth by the board. We've talked about that. Administers the services, programs, and operations of the association, provides information, training, and leadership, acts in the best interest of the association, and then keeps the board informed on progress of key projects. All right, so before I go forward into meetings, I'm just going to take a look at some of the questions if it's something that I've already addressed so that I can make sure we do this. Let's see. All right. Somebody asked a question, how does workers' comp apply to COVID for our staff? That really is a little more detailed question. It depends upon whether or not those staff are contracted specifically with the association, if they're employees or not, or if they're independent contractors. You need to take a look at really take a look at the policy itself. If there's any exclusions for COVID, for example, it's a new area everybody's dealing with right now. So it's a little more specific question. You have to take a look at the policy that you have in place. Let's see, we haven't addressed this, but somebody asked, how can we legally handle political signs in yards during the election time when we don't allow signs? So this is a good question. I think it's one that we should talk about because we're in an election year. Take a look at your documents and see if there's a prohibition on signs. If you have a prohibition on signs in your declaration, it's difficult to establish a rule that would otherwise then allow it, because you may be giving up your ability to enforce that sign restriction for anything aside from political signs. So be careful with that. There is some argument as to whether or not you're required to allow political signs as a matter of free speech. I think that if you have this as an issue that you don't want to allow them, but somebody is pressing you for it, you should really talk with your manager and with your attorney about it. Somebody asked a question of what is D&O? I'm sorry, that means directors and officers liability. So that protects you as board members for any action that may be brought against the board members individually, or if it's brought against the association because of an action that's taken by the board. So your directors and officers liability policy would then cover you in most instances for actions brought that way. There are some exclusions depending on if it's a breach of contract claim. Sometimes there's exclusions for that. So you need to make sure that you're properly covered and talk with your insurance agent to make sure, hey, is there any loophole? Is there any gap here that we need to know about? Are we properly covered? Do we need to increase our coverage here? Somebody asked a good question, says, my community is a POA. Is there a legal difference between a homeowners association and a POA, which is a property owners association? Typically not. The only thing is that if you're a property owners association that's not residential in nature, there can be some differences in terms of the statutes that apply. But I work with a lot of very large HOAs that are master associations that may be called a property owners association. It's really no difference in terms of just the name, but it really depends on if you're a commercial versus a residential. If you're a residential and you call yourself a POA versus an HOA, there's no difference in terms of the state statutes there. A good question here is, what is the difference between a sign and a flag other than the US flag? Can they be considered the same? We've seen this issue come up where maybe there's a prohibition on flags but not on signs, or vice versa, and somebody's trying to use that as a loophole. Not to duck out of this too much, but it does depend on the language that's in your governing documents. We would need to take a look at that and then determine what the intent is of it. If it's, I've heard somebody state that if it's a temporary flagpole, for example, if it's not permanently affixed, then it might not be in violation of the documents because it says you can't affix to the property or something like that. So we need to take a look at your documents there and see what the intent is. Obviously, there's a sensitive issue if somebody wants to fly the U.S. flag, or if it's, for one of the state of Florida, or for one of the military branches, or the POW MIA flags, something like that. We want to be sensitive to that, but also you have to be sensitive to the request there, but also stay in line with what the documents require. And that's where you really need to work with your manager and with your attorney on it. All right, so I'm going to hold off on further questions right now for a little bit here, and we're going to keep going through the presentation. So going through it, because I saw a question on meetings here too. So annual meetings, that's your membership meeting. You have to have it once a year. It's typical when your budget's presented. That's usually more towards the end of the year. Maybe if you have a spring meeting, you can have a reminder for everybody as to how that budget was adopted. But really what's going to take place is your election is going to take place at your annual meeting, unless otherwise provided in your documents. And also you're going to do a review of the year. But one thing that I've had happen is some homeowners think that the annual meeting is their one time during the year that they can undo certain things that the board has done, or they can make motions that bind the association. The main thing to remember is that members are only able to vote on anything that's allowed in the governing documents or in the state statute. And it's really limited. Most actions by the association are carried out by the board of directors. Just because you're having your annual meeting, it's not, I kind of joke that it's not like it's the one magical night a year where they get to make decisions that otherwise the board would be making, or to rescind anything the board may have done. That's not the intent. The intent is that you elect people to the board, and if that was a board decision, then the board can go moving forward to maybe change any policies or anything else, but it's not for the members to vote on specifically. Board meetings, the frequency is going to be defined in your documents. Sometimes it may say that you have to have board meetings at least quarterly. You can always, almost, unless otherwise restricted, but really the state statutes allow you to call a meeting with at least 48 hours notice. And usually that's when as needed. So you may have to have meetings at least quarterly, but there's nothing preventing you from having them monthly, or if you need to call a meeting in 2 weeks because something came up, that's of course what you want to do. You just need to make sure that you provide appropriate notice. Then you can have other member meetings. That would be for anything outside of your annual meeting. Maybe your annual meeting's in October, but you're in April and you want to vote on something, maybe a change to the covenants, or a special assessment that requires member votes. Anything that requires a member vote that you don't want to wait to your annual meeting, you could call a special membership meeting for. And that typically requires 14 days notice at least. It depends on what your governing documents may provide. Committee meetings. So for condos, any committees that you have, their meetings are going to be noticed in the same way as a board of director meeting, which means that you have to post it physically on the property with at least 48 hours notice. For HOAs, by statute, the two committees, types of committee meetings that have to be noticed, just like a board meeting, are a committee like an architectural committee, or if it's a committee that has the ability to disperse funds. So if you have a committee that's authorized to disperse funds and has a certain budget, they have to actually notice that meeting as in the same manner as a board of director meeting. Now you still need to look at your governing documents because it may still state that committee meetings shall be provided with notice in the same manner as a board of director meeting. I'm just telling you what the minimum requirement is for state statute there. So meeting requirements to quorum. A quorum is required for official business to occur. Any interaction contributing to the development of ideas constitutes a meeting. And so in this is where I bring up, if you look under the quorum in that second bullet point there, I call this the barbecue rule. What I really mean by that is if you have a community barbecue, which sadly I'm sure most of you haven't had because of COVID and everything, but in general, if you have a majority of the board members present and they are talking about association issues, whether it's we've got an upcoming meeting or a performance issue or anything else that affects the association, that's technically considered a meeting that needs to be noticed as required. And we just talked about whether it's 48 hours notice or whatever. A meeting, it's not just when you're going to be voting on something. So another good example is I've seen a lot of communities that say, well, we're going to have a budget workshop and we're going to have the board there, but we're not noticing it as a meeting because we're not going to be voting on anything. You still have to notice that as a meeting because it's any interaction contributing to the development of ideas constitutes a meeting. So be mindful of that. Now, in practicality, what could happen there? Somebody could seek to invalidate an action that was made outside of a meeting. They could, in the condominium context, there's a way that you can file a complaint with the division where they can investigate it, and there's a potential fine that can be imposed on the association. So really, it's impractical to state that you're not going to talk about association business outside of a board meeting. If you do that, at least do it in a way that you don't have a quorum of the board members there. So if you have 2 out of the 5 members, for example, or try to limit your discussion and say, hey, I think we should bring this up at the next board meeting because I'm not happy with this. Yeah, I think that's a good idea. Let's put it on the agenda. And then leave it to that so that then you're doing it at the board meeting and then members can witness that discussion. That's the main thing. The frequency for meetings is determined in the governing documents. We talked about that. Proper notice is required. You need to look at, there are specific meeting notice requirements. I talked about the default is 48 hours, but there are instances where you have to provide 14 days written notice. That's for condos, co-ops, and for HOAs whenever you are passing a rule regarding parcel or unit use that's going to affect their unit. That's an example of something where you have to actually have 14 days notice of the meeting and it has to be mailed out to the members. If you're going to be passing a special assessment, that also has to be done with 14 days. Even if the board could vote on it at a board meeting, you still have to provide 14 days written notice to the membership, not just posting it. And you also have to, in a special assessment context, you have to state the purpose of the assessment and the anticipated amount of the assessment too. All right, let's see here. The other thing too that I want to mention is that Florida government in the sunshine does not apply to associations. You sometimes hear that you're not operating in the sunshine. Well, in fact, that only applies to government and administrative agencies. The association is not one of those entities. However, the statutes governing associations really provide for the same thing, where you have to have open meetings, members are able to attend. You're supposed to notice as a meeting when you ever have a quorum of the board talking about anything that, any ideas. So that's where it's similar to it, but it's not the exact same thing. All right. All right, so some of the quorum requirements for condos. A member meeting requires a majority of the voting interests. A board meeting requires a simple majority of the members. The quorum is not required for election if 20% of eligible voters cast a ballot to have a valid election. We'll talk about that a little bit later. All right. And then suspended voting rights do not count either. And we'll talk about that too a little bit later in terms of other suspension rights. For HOAs, the difference between condos and HOAs from a quorum requirement is that for HOAs, the maximum that a quorum needs to be pursuant to your governing documents is 30% of the voting interests. So if your governing documents maybe have an older HOA and your bylaws state that a majority of the members need to be there in order for a quorum to be met, state statute actually will trump that. There's a little bit of argument there in terms of retroactive and when that statute was put in place versus the age of your documents. But by and large, the advice that we've given to clients is that the 30% number is going to apply. So that makes it easier to have your membership meeting because it's a lower quorum requirement. You can actually have a lower quorum requirement if it's provided for in your bylaws. In terms of for board meetings, it's a majority of the number of directors, same thing for a condo. Decisions that require a vote of the members must be made by a majority at a meeting where a quorum is obtained. And the same thing is suspending voting rights do not count. So board meeting attendance, it's open to all unit owners. Anytime a quorum is present, unit owners have the right to attend unless, and then these are the two ways that you can have closed board meetings. One is if legal counsel is present for the purpose of providing legal advice regarding pending or possible litigation. So remember this, and I know a lot of associations have invited attorneys, myself, to meetings, and it's not technically a meeting where you're addressing proposed or pending litigation. That arguably then should be open to the membership. The other thing too is that even if it's closed to the membership, you still have to notice it as a meeting, and what you would normally do is place as an agenda item, closed meeting with legal counsel regarding proposed or pending litigation. And that way it's posted, members know that you're meeting, but that they're not really going to be able to attend it. So that's the other important thing to note. The other type of meeting that can be closed is a meeting where personnel matters are being addressed. Closed board meetings are permitted in that instance, and legal counsel is not required to be present. There is an interpretation issue that I've seen come up, and we haven't had clear guidance from either the courts or from arbitrators as what constitutes a personnel matter. I tend to err on the side of it's somebody that you have right now, and if it's a performance issue or some type of HR issue or something like that, if it's for the purpose of interviewing a new management company, for example, or a new vendor, I err on the side that that should still be done in an open board meeting. I don't know that that's considered a personnel matter, but we don't have guidance on it. So if you have a question on it, you should talk to your manager, depending on what you're trying to have a closed meeting for, or with your legal counsel on it. For condos, really it's for condos and HOAs, you're able to participate as a board member in a manner. If you're not there in person, you can attend via Zoom, FaceTime, Skype, whatever it is, anything that is otherwise like live participation, because you're not allowed to have proxies for board meetings, but you are allowed to call in. So that's the thing that you're allowed to do, and that's for condos and for HOAs. Other thing with emails, I usually get a lot of questions regarding emails. Emails are deemed to be an effective way, and you're allowed to use it as a means of communication, but you cannot do it to cast a vote. So you cannot vote by email. The main thing and the theme that I've tried to mention here is that you need to have open board meetings where the decisions are being made at the meeting and voted on in front of the membership. If you do everything by email, members are going to be upset because they're going to say, hey, you're doing everything, there's no transparency, and we should be able to participate in this. It should be done in an open meeting. And so this was the case. The law was in place for, I want to say 4 years or so, 4 or 5 years for condos. And then in July of 2018, they also added it for HOAs because there may have been a loophole as to whether or not you could vote by email or not. So The question then is, well, what are we supposed to use emails for? Because it's not practical for us to save everything just for the board meeting. What I would say is use email as a way of saying, hey, I think we have an issue here. I think we need to bring this up at our next board meeting. I think we should direct our manager to go out and get a new bid, or they should take a look at this or talk to our vendor about this and then report back at the meeting. Is everybody okay with that? Yes. Okay, great. So that way you're kind of teeing it up for what's going to happen at the board meeting. You don't want to make it seem though that that you're using the emails to say, all right, well, here's what I like about this contract. Here's what I don't like. And so when I go to the meeting, I'm going to vote this way. You don't want to have that happen so that by the time you get to the board meeting, that when it's brought up on the agenda to hire somebody, that somebody makes a motion and then second it, and then there's no discussion and there's a unanimous vote because you've already addressed it by email. That's where people are going to be upset because they're going to feel like you've already kind of vetted and worked through everything outside of the meeting. So that's what you want to try to avoid. The other thing too to note about emails, and I talk about official records later, but just be cognizant of the fact that your emails that you send as board members, whether or not a member can request copies of them right away, they are going to be discoverable if there's ever a lawsuit or anything brought, that they can ask for copies of those emails. So just be very careful as to what you're putting in your emails. The other thing too that I recommend, and I just had a meeting with a client the other night with some new board members, is create a new Gmail address or whatever your email platform is, but create a new address that's only used for your association matters, and be strict, kind of stay disciplined with that, so that if there's ever an issue, you can say, all right, well, here's all my emails. Here's this email address. You know that you don't have to provide your other personal email address and then have some other lawyers sifting through your emails to determine whether or not, you send out an email on this date about this issue. You can just turn over your association email address. The other thing that's nice about that is that once you get off the board, you can decide to turn over that email to the new board member, and then you kind of have institutional knowledge a little bit. They can search through emails themselves without having to contact you about it. All right, so owner participation and personality problems is what I like to put here. Owners may speak on any designated agenda item. Now, the thing is that you can adopt rules regarding this, reasonable rules. And so if you're having problems with owners hijacking meetings or saying they're allowed to talk for 5 or 10 minutes, the statute says they're allowed to talk for a reasonable period of time, but it's not defined. And so that's where you really want to establish reasonable rules to state that, okay, you're allowed to speak at a meeting, but we're going to ask that you sign in. We're going to place it on this part of the agenda, and you're limited to 3 minutes on an agenda item. That's a way to pass a reasonable rule. And what I always recommend is doing that before you have a problem, so that when a problem exists, you don't have to feel like you're making up something on the spot during the meeting. And that's where members feel like you might be picking on them or you're not uniform. So make sure you do that. We've worked with a bunch of our clients that help establish these, and I think it's good to have in place. The other thing too is kind of going into the recording part. If you have owners that are asking to record or have been recording meetings, you're also allowed to adopt rules on that. And so what you might ask, well, what are some rules you can adopt? Well, one thing is, okay, if you're going to tape record the meeting, you have to notify us when you get there, and you have to place the tape recorder in a place that everybody can see it. You can't move it. That way you know that you're being recorded, and instead of somebody like kind of discreetly, I'm kind of, if you can't see me here, I'm kind of motioning to my phone in my pocket, and I start hitting the record button without telling anybody about it. That's one thing you could do for video recording. You can state that you need to notify us in advance. I've seen some communities require like advance notice, like a day in advance, and I guess that could be so that the association can then choose whether or not they would like to video record it, so that if somebody tries video recording and then they edit it later, you have something to compare it against. I know this sounds absurd, but this happens in communities. The other thing is to make sure that they're stationary so that they're not walking around like a camera crew. I gave one time a Stanley Kubrick example, and I guess that's almost too old school. I'm trying to think, I don't know, Christopher Nolan or something like that. It's not walking around with a camcorder here. It's, okay, if you're going to do it, you need to keep it stationary. You can't move it around during the meeting. All right. The other thing too that I like to mention is that when you're in this is kind of advice for you for board members. When you're having board meetings, you're going to have problem owners at some time. They're allowed to speak on an agenda item. It's not a back and forth Q&A session. Just because they start peppering you with questions doesn't mean that you then are on the spot and you have to answer every single one of them. The main thing, and I've had to attend these meetings, all of the attorneys in our office at some point have had to attend a meeting where somebody is saying, they have a list of 10 questions. They say, why did you do this? I demand an answer to this. And at some point we've had to answer, Thank you for your comment. The board will consider it. Thank you for your comment. Thank you for your comment. It kind of, people get upset with that, but at the same time, it sends the message that we are not expected here to answer every single one of your questions, especially if it's something that may, if it's being tape recorded, if it's going to bind us in some way. We should have the ability to review that, and if we feel like we need to address it later, we'll do so. So don't feel like you have to answer every question. You are able to. If it's a quick question that you can answer, of course, feel free to do so. But if you're put on the spot, you don't need to do it, especially for something that's not on the agenda either. All right, so planning board meetings, you want to define the purpose, create an agenda, date, time, and location, place on the agenda what you're going to be establishing. For a condo association, you are required to establish an agenda. For HOAs, it's not specifically required by statute. You're required to post a notice of the meeting, but you have to take a look at your governing documents. It may require it. But if you are required to post an agenda, you want to be specific with it. There are some arguments as to whether or not you can just place a generic new business without also having agenda items listed out underneath it. If you are going to add an item to the agenda, there is a way that you can make a motion and second it to add it to the agenda before you actually address it. So just be considerate of that. The main thing is planning in advance so that you don't want to make it seem like you hid something from the membership where you didn't put it on the agenda and then it was brought up and a motion was passed and then somebody could say, I didn't know that you're going to be discussing that. Otherwise, I would have attended. And you say, well, we kind of added it during the meeting. That's what you want to try to avoid. So try to be as proactive as possible in figuring out what do I need to add as new business. The other thing is invite the appropriate people. If you need to bring your attorney there or your insurance agent, anybody else, consider that. It's very helpful. Sometimes you can have questions right away, during the meeting, or if there's a question that the membership has, and you want to bring the landscaper there, I think it's good to have them. Then that puts a face with the membership, and I think it helps answer certain questions. You might get the members off your back to let the actual vendor answer questions rather than the members accusing the board of not doing their job of staying on top of the vendors or whatever. All right, so some meeting hints. You want to start on time, stick to the agenda. Robert's Rules of Order, I put that in there, but really it's some type of parliamentary procedure. And then the key components are motions, resolutions, a debate, and then vote on it. The meeting minutes. Obviously, your meeting minutes, that's an important document maintained by the association, serves as the official record of the organization, and it serves as the basis of any action taken by the board. The main thing is that people aren't going to remember unless they've actually tape recorded it, who said what at the meeting, but they are going to see what's in the minutes as to the action that's been taken. And so really going into the next part, which is the content of the minutes, as an attorney, I always like to see minutes that are as concise as possible. What was the action that was taken? If you start putting in too much of this person brought up this issue, this person countered this, and this, and so every single agenda item is 2 paragraphs and your minutes are 3 pages long, that's something for me that I'm always uneasy as an attorney, because if there's a legal issue that comes out later, attorneys are always going to be looking at the minutes for your meetings. They're going to say, hey, you're bringing this issue now, but it looks like you guys brought it up 6 years ago and nobody did anything about it. It seems like you guys were on notice and you should have brought a claim earlier. That might bring a defense for a statute of limitations, for example. So just be mindful of that. If you have members that are saying, I disagree with what the board did and I demand that it be placed in the minutes that I objected to this and the board acted contrary to it. Or even if a board member says that, the only thing that you're required to have is that if there was a motion made, if there was a second, and then the results of the motion, and that there was debate, and that there was the results of the motion. So I challenge you to kind of keep your minutes concise, try to keep them to 1 page if possible. I always say that the minutes are not meant to be a transcription. It's not a deposition or a trial transcript. If somebody wants it, that's why they have the ability to tape record the meeting so they can see what was said. So, and I see a lot of associations too that will tape record the meetings for the purpose of drafting the minutes. I think that's fine. I usually recommend of getting rid of the tape recordings once you're done with drafting the minutes, though. That's just what I usually recommend there. All right, so I'm going to jump into elections, but first I'm going to take a look at just some of the questions that we may have and see if there's anything else that may have been addressed here. Shayna asked a good question. Should we restate the motion in the minutes? Yes, absolutely. So what you're going to be doing is the minutes are going to say a motion was made and you want to make sure you clearly state what the motion is. And then you're going to say there was seconded and then all in favor. It's usually pretty common to state who made the motion, who seconded. I've actually looked into this and it's not technically required, but I think it's fine. It's good practice to do it. but it's actually one of the interesting things that I've seen, that you're actually not required to do it. But yes, you need to restate the motion. That's why it's very important to state, okay, what is the actual motion that's being made, so that we can reflect it in the minutes. So that's a good question from Shana. She asked that in the chat here. All right, I'm just gonna take a look at a couple other questions here. In general, is the D&O coverage part of the unit owner's policy or the association policy? If you're an officer, should you have it added to your unit owner policy as an endorsement, even if it isn't primary coverage? Clay asked that. That's a good question. No, D&O coverage is typically part of your association policy. It's a separate policy that's maintained by the association. You as a board member, I mean, I suppose you could do this if you really wanted to have extra protection, but you as a board member should not be having to pay out of pocket personally for having your own policy or an endorsement to your unit owner policy. And I don't know that carriers typically do that anyways under your HO6 policy, which is your property policy for your unit, or for your HO3 policy for your home. So it's going to be a policy that's going to be, the association is going to have specific, it's its own separate policy. Mike asks, can the board meet without members to discuss administrative procedures? Again, if it's regarding association business or functions, it's deemed to be a meeting. And so if you have 3 out of 5 members there, that's deemed to be a board meeting that should be noticed. The answer, the go around to this is have 2 members meet. Maybe you have a task force of the board that looks into certain issues so that you don't have to have it at a board meeting and then they report back to the board with some recommendations. That's what I typically see done in order to avoid, you know, the quorum and the meeting notice requirements. And Philip asks, when you're giving notice, who are you giving notice to, the board or the members? That's a good question. You have 2 things in your documents. You have a notice that's you're required if you're the president calling the meeting. You're required to give notice to the other board members in a certain manner. You need to look at your bylaws for it. What I've been focusing on is really notice to the membership, which is at least 48 hours notice as required by state statute. So you're giving notice to the members that the board's going to be meeting on a certain date, where the date, time, and location is, what the agenda is going to be, and that they have the opportunity to attend it. Shannon says, if members want to Zoom in for a membership meeting, does that count towards a quorum for membership meetings, not board meetings? And how are Zoom meetings that are recorded treated when it comes to records? Do you recommend deleting the video after minutes are completed? So this is a great question from Shannon. The law is unsettled on this, and I think we're going to see some changes to the state statute regarding having virtual membership meetings. What I've been recommending is that I still consider members, they need to still submit a proxy that appearing via Zoom alone does not constitute attendance at the meeting. Now, you may talk to different attorneys, and I think that there's an argument to be made that if you can verify the member via the Zoom call, that the only difference is that they're not there in person in front of you. I think we could see a statutory change, but what I've been recommending for membership meetings is to have some type of a physical location, and then you put in there, this physical location is for the purpose of you dropping off a proxy if you haven't already done so, but we really ask that you then attend via Zoom, so that because of social distancing and so on, and then that whoever you're naming as your proxy holder needs to be there in person at the meeting, because that's the whole point of it, right? If you execute a proxy, it's because I can't be there, but this person is going to be there for me, that person should still show up. And so what I recommend doing is, and what a lot of associations have been doing, and what most people do, is that they say, well, if I can't be there, they don't really fill out the name of the proxy holder. What they do is they leave it blank, and then by default, the proxy holder is the president, and so the president might show up. The other thing kind of going along with that is, what do you do with the Zoom recording? I think it's arguable if that's an official record. I think I could see a good argument being made for it. What I would recommend doing is deleting it if you're using it for the purpose of drafting the meeting, the minutes, and then getting rid of it. Again, it's just because it's just, for me, conservative as an attorney, that if somebody brings up something that wasn't on the agenda, but somebody brought it up and then becomes a legal issue later on, and somebody tries to point back at that by saying, hey, somebody brought this up at your member meeting and you should have done something. I'd rather that, you know, be tied to the minutes rather than random comments that are coming out of somewhere that really nobody knew about, and that now we're required, or it's shown to have created an obligation for us to look into it further. I'd rather that just be reflected in the minutes than it is by any type of recording. All right, I'm having trouble with my mouse here. All right, let's see. When would the D&O insurance be issued? Okay, typically you always have a D&O insurance policy in place. You should always have that. You may have a renewal of it, and that's where you need to talk with your agent. So talk with your agent right now as to what policies you have in place. You're almost, I mean, you have to have D&O. I mean, I don't say have to have, but I would almost insist on it just to protect you as individuals, as board members, to make sure that you have it in place. All right. All right. Folks, we're going to take a quick break here, and I'm going to jump back in before we jump into elections. And I will be right back. So if everybody just take a quick break, I'll be back in about 2 minutes, okay? Get started in just a minute here, folks. All right. All right, everybody. Thanks for bearing with me here. I hope everybody was able to get up and stretch their legs for a second here. So I'm just going to go through another question here is, our docs require that all regular board meetings be posted with 48 hours notice? 720 says no notice is required if state of emergency is announced. If COVID-19 lasts more than 18 more months, does that mean our board doesn't have to notice regular meetings for 18 months? It's a great question from Alex here because of COVID-19, the uncertainty. So you have the state of emergency, you have the emergency powers under the Chapter 720, Chapter 17, and 719 all have emergency powers. What the statute says there is that you can notice meetings in a manner as practical as possible. And so the intent of that was really those statutes, I think, are going to be amended because they deal with property damage. And so the idea is, hey, a storm just came through or something happened, and we need to call a meeting ASAP because we need to authorize X, Y, and Z. We need to pass a special assessment. And it said, hey, you don't need to wait 48 hours in order to do that. Just give as much notice as you can. It still need to be noticed, but the emergency powers do not give you the ability to conduct business outside of a board meeting if you're otherwise able to call a meeting to order. So that's the main thing. You know, if there's something that comes up that's an emergency and you need to wait, whether it's because of COVID, maybe there's some mandate and you need to take action from the board from a state mandate or a local municipality or something along those lines. That may be where you still call a meeting with less than 48 hours notice, but it's not to be used to get around having to have actual board meetings. The other thing that's interesting too is that the Division of Condominiums, Timeshares, and Mobile Homes has stated that they interpret the emergency powers, first of all, that they interpret the statute to apply outside of property damage, even though the statute doesn't say it, but then they said that has expired. I believe they said that it was at the end of June. And so it kind of raises in the question, does the statute actually apply or not? You know, we've been advising, I think there's certain actions you can take, especially with closing down the common areas in the pools. I think that's a board function anyways, but the emergency powers gave additional authority to do that. But nothing in there gives you the ability to get around the regular notice requirements for meetings and everything. All right, so what I'm going to do is, let me see. Actually, Michelle had, I think, some follow-up questions on the D&O policy. How is D&O used, or why would the board members be sued? Well, board members can be sued. Sometimes people think that the board members acted outside of their fiduciary duty, and they want to sue them individually because they think they acted so far outside of what their obligations were that they're going to name them personally. That has happened sometimes. I will tell you again that it's very difficult to successfully sue a board member unless, really the main thing is, unless you can show that there's some type of personal financial interest or something that they're doing without disclosing it and going through the proper protocols with the association, and that's what's guiding, or they're obviously, if they're stealing funds or doing something that's illegal or something so outside of the realm of what a reasonable board member would be doing, that's where a board member could be sued individually, and you'd want to have the D&O policy. But I've seen it where people just do it because they want to antagonize the board, and they'll name them personally because they see them named in a lawsuit. And that's why you want to make sure you have your D&O policy there to provide for coverage. And then I think I answered Dave's question too, but can board members meet in social gatherings or get together without a vote to discuss projects? Again, if you have a majority of the board members there, it's technically considered a meeting, so you want to limit that to less than a majority, or you need to call that as a proper meeting, workshop, whatever you want to call it. All right, everyone. All right, I'm going to go through the elections. So from the condo side, what I'm going to talk about here is it's largely focused on the condos, but I ask that the other people who live in other communities look at this because I think the condo form of election is the best process that we have, and it's a good way for to keep an orderly election. And so it's a lot less likely that anything's going to be screwed up. And the reason is because the state statute mandates most of what has to happen. And so any vacancy on the board should be conducted by a secret ballot at the election. Provisions may be made in the bylaws for board member term limits. If term limits are not defined in the bylaws, then the terms expire upon the election of successors, so it's at your next meeting. A candidate must be eligible to serve on the board at the time of the deadline for submitting the notice of intent to run, which is 40 days in advance. So we're going to talk about that too in just a second here. So for condos, I wanted to update you on this. As of July of 18, they've expanded the term limits, what you're allowed to do. So directors in a condominium may now have longer than 2-year terms if in the bylaws. The default was a 1-year term unless the bylaws provided for 2-year staggered terms. So you still need to update your bylaws to provide for, let's say, a 3-year staggered term, but now you're allowed to do it. The other thing is that for condos, you're not able to serve for more than 8 consecutive years on the board unless you either attain 2/3 votes of the votes cast at the election, or if there aren't more candidates and vacancies. Now, the thing with this, though, is that the division has come out and interpreted to say, hey, we actually think that that the 8 years runs from 2018 going forward. So we actually don't need to worry about this for a while, potentially, unless somebody challenges it and an arbitrator or a judge thinks otherwise. But that's the guidance that we've received so far. So for condos, this is just the kind of the overview of the election process. The first notice of the election must be mailed or delivered no less than 60 days prior to the election. So you have a first notice that goes out, and it's a call for candidates. Candidates have to be eligible and submit their name within 40 days. We talked about that. And then you have a candidate information sheet that must be provided no less than 35 days. So I guess you have to get your name in 40 days prior, and then you have another 5 days to get your sheet in if you didn't already do that. The second notice that goes out then is it's not less than 14 days and not more than 34 days prior. That's after the cutoff date to get your name in, and it includes the meeting agenda. And then it has the official ballot listing all the candidates and the candidate information sheets that they've been provided. So the nice thing about this is that there's no interpretation with it. It basically says you need to be eligible to run for the board and you need to get your name in at least 40 days in advance. If you don't, you're not on the ballot. And the ballot's listed alphabetically. There's no favoritism. I like this because there's no nominating committee, which then can get a little weird because nominating committees are typically appointed by the board. And so, and if those board members run again, the nominating committees may nominate the board member again. I like this process because it's, as long as you're eligible, you get your name in on time, you get on the ballot. That's why I like the process for the election. For HOAs, it's different. And I should say that the condo form is also very similar in the co-op context. I think we have a couple of co-op members in here. It's a very similar election process as the condo one. For HOAs, the election must be held on the date of the annual meeting or as stated in the bylaws. It must be conducted in accordance with the governing documents. The board must be elected by a plurality of the votes. That's the same thing with the condo side. Same thing here. The eligibility requirements is the same for condos and for co-ops, is that any person that's delinquent more than 90 days in a monetary obligation or has been convicted of a felony, has not had civil rights restored for at least 5 years, is not eligible to serve on the board. A board member may nominate himself or herself as a candidate at a meeting where the election's to be held unless the governing documents provide process for nominating in advance. So this is the big difference between condos and HOAs. For condos, you get your name in at a certain time, and then if you're not on, I've even seen arbitration decisions where somebody faxed it over at like 12:10 in the morning to the management company, and it was on the 34th, or I'm sorry, the 39th day before the election, and the arbitrator said, nope, you got to get it in 40 days prior. So there's really, it's pretty black and white. The thing with HOAs is that if you don't have a nomination in advance process, and you need to look at your bylaws to provide for this, you have to allow nominations from the floor, and you really aren't even supposed to send out a ballot in advance of the meeting, because by sending out a ballot, you're implying that there's a way to get your name in by a certain date to get on the ballot, where in reality is you just state, what you're supposed to state is, show up for the annual meeting, everybody's going to nominate themselves from the floor, and you can vote for your directors there. You can see how that becomes messy because you don't know who's going to be running. It's better to have the nomination in advance process so you can get rid of that. I have seen associations, there's an arbitration decision that I always cite here, where the HOA had basically done the condo form of election for 10 years, but a homeowner challenged it because he tried to get his name, he tried to nominate himself from the floor, I believe. And they said, no, you can't do that. You didn't get your name in on time. And they challenged the election results. And the arbitrator said that the homeowner was right by saying, if it's not in your bylaws, you can't establish that as a policy. You have to go by what your bylaws provide, which means that you have to allow nominations from the floor. So past conduct doesn't really help you on this. You need to update your bylaws if you haven't done so to establish whatever the process is that you've been doing or want to do. The election, the provision in the statute was updated as of July of 18. If an election is not required because there are fewer or equal candidates and vacancies, and nominations from the floor are not required. So that's the key thing, is that you have to eliminate nominations from the floor in your bylaws. Then write-in nominations are not permitted, and those candidates commence service whether or not you obtain quorum at the meeting. So that's the other nice thing about doing away from nominations from the floor, is that if you have that cutoff period and you have 3 people running for 3 spots, you don't have to worry about making quorum at your annual meeting. Those 3 people are already on the board. Whereas if you get maybe 3 people that want to run for 3 spots and nobody nominates themselves from the floor, but you couldn't reach quorum at the annual meeting, those 3 people aren't seated on the board for a new term. The previous board members are holdover directors, and it becomes really messy. So you can kind of tell that. That's why it's good to have a nomination in advance process, so you can know if you're going to need to have your election or not. There's a provision in the statute regarding recalls. I'm not going to go through it too much, except just to say that recall is a very specific process. You have to react quickly to it. A recall is a way to remove a board member before their term is up, and the only way that you can remove a board member is by membership vote pursuant to a recall attempt. So just note that if you are served with a recall petition, you have 5 business days to evaluate it, and if you're going to reject it, and there's only limited ways that you can reject a recall petition, it has to be stated at that meeting. So if you do get one of those, you need to contact your attorney really to take a look at it. If you're unsure of whether or not it's a valid recall attempt, because it's a very quick moving process. So I just want you all to be mindful of that. All right, proxy rules for condo. A limited proxy means that you must vote as specified on the proxy. So what that means, it says, I designate so-and-so as my proxy holder, and they get to exercise any powers that I may otherwise have. But as to this specific issue, I direct them to vote yes or no on it. And that's what a limited proxy is. A general proxy allows the proxy to use their best judgment in voting. Voting by proxy is not permitted for the board member election unless you're a really small condo association. Limited and general proxies may be used to establish a quorum. The main thing to note is that for condos, pretty much anything that you vote on as a member for a condo needs to be done by limited proxy. There are some exceptions there, but for the most part, you need to have a limited proxy for it. So you're not allowed to just say, I can't show up, my neighbor's my proxy, and I'll let them vote in their discretion. I trust them to vote to do what's right. For a condo, you need to actually say, I can't be here, so-and-so is my proxy, but on this issue, I'm voting yes or no on it. The proxy is valid for 90 days, so that if you can't make your quorum and you need to adjourn it to a later date, or if you need to reschedule a meeting, the proxy is still good for 90 days from the date of the original meeting. For HOAs, same thing. Directors may not vote by proxy at a board meeting. Members have the right to vote by proxy. It may be limited pursuant to the governing documents. You need to look at your bylaws. A proxy is only valid for the meeting for which it's intended, and it expires 90 days. The thing, though, with HOAs is that there really is no limited proxy requirement in the HOA statute. So I have seen, and again, it depends on what your documents may require, but I have seen instances where homeowners have issued general proxies, and that the proxy holder is able to decide how they want to vote on certain issues. So that's a key difference between condos and for HOAs. All right, so that's the main thing what I have for elections. The main thing that I just want to impress on you is that if you're in a homeowner association, if you're not sure, take a look at your election process. The other thing that I would talk about to everybody about is, because of COVID right now, and because of the uncertainty, and there was a question before about having Zoom meetings, is really take a look into electronic voting. I've had some communities that have gone through it, and it's worked out really well. The thing is that you need some lead time for it, because members have to opt in to vote electronically, and you want to give them enough time for the new company to send that out to people and to get people to consent to vote electronically. But once you have it, then the nice thing is that if the only thing that they're voting on is the election, you're not really as worried about getting the proxies in if you can otherwise, if your election is determined by the number of ballots cast for the election, for example. So I'd take a look at that right now. If you're in July right now and maybe you have your annual meeting in October or November, now's the time to really be looking at what your election process is and if you're going to be doing electronic voting. And I would say the same thing for condos, not for the election process itself, but just for the electronic voting part, and whether or not that may be a better way to keep people from feeling they need to show up in person or be concerned about that, because they can vote easier even than just the mail-in ballot by just clicking on something through the electronic voting process. All right, so we're going to talk about financials, reporting budgets and reserves. So we're going to talk about your budgets, your operations, reserves, and the accounting method. You want to monitor the accounting records, must be open for inspection. Accuracy, of course, is critical. You need to establish assessments, both regular assessments and then special assessments are unplanned items that are still covered by your budget that you're allowed to do as an association. And then we'll talk about financial reporting requirements. All right, your budget, remember the main thing, if I can impress on you for the budget, is that it's a roadmap and it's an estimate, but it's not the Bible in terms of that, that if you go beyond it, that you can no longer spend money on that budget item for the rest of the year. So I've seen associations that say, hey, Ed, it's October or it's September, but we've already, we've reached our budget limit for property maintenance, so we're gonna hold off on any projects until the next year. I wouldn't recommend doing that if that item could get worse or if somebody could get injured. The main thing is that it's an estimate. It's not something that's holding you to those amounts. And so if you go over budget, what you do then is you adjust it for your next year's budget to make sure that you catch up and that you're properly funding it. But I don't want you to think that your budget is something that you are tied to specifically, that you can't go over that by 1 penny. You know, that just means that you need to tweak those numbers for your next year's budget. Your proposed budget will include all daily operational expenses and estimated revenues. For condos, the owners are entitled to 14 days written notice of the budget meeting. For HOAs, you're actually not required to send a copy of the budget by statute. You are required to provide 14 days notice at any meeting where an assessment is going to be considered. So that's going to be your budget meeting. And most associations will still mail out a copy of the budget just for transparency purposes. Let's see here. And I know we had some questions come in recently. I'm going to hold those to the end just because I want to make sure we get through what I have on the slide. So if you have questions and I haven't answered them, I'll be happy to answer them later. All right, your annual budget, your governing documents is going to set forth the responsibilities for preparing and implementing and funding the annual budget. Most budgets contain your administrative costs, maintenance, taxes, insurance, reserves, pretty much everything. The nice thing is that when you have a budget, you're not reinventing the wheel next year. You're taking a look at what works, and if you need to update anything or add a line item to the budget, that's what you're doing. You're not reinventing the wheel. You need to determine if you're on a cash basis versus an accrual basis. In terms of a cash basis, income is recorded when it's received and expenses are recorded when paid. Accrual basis is income is recorded when earned and expenses are recorded when incurred. Financial reports. I have this as a reminder that this is the reporting requirement you have each year depending on your total annual revenues. So if you have less than 150,000, you just have a report of cash receipts of expenditure and expenditures. If you're between 150,000 to 300,000, it's a compiled statement. If it's 300,000 to 500,000, it's a reviewed statement, and anything over 500,000 or 500 or more is an audit. And so that, depending on where you're at, that's what you're going to have to do each year. Now you have the ability to vote to reduce the financial reporting requirements, but it requires majority of approval of the members at a meeting where a quorum is met. So the board alone cannot say, hey, we don't want to do an audit this year, we're just going to do a reviewed statement. That actually requires membership approval before you do that. Funding the budget, it's basically assessments required from each owner. That's going to be 90 to 99% of what your budget's going to be made of in terms of income. The owner or the parcel serves as security, depending on the type of community that you're living in. Other sources of revenue may come from rent, interest, but for the most part, it's going to be assessments. And what you're doing is, the first thing is, what are our expenses are going to be? And let's say you have $1 million budget, right? So then you say, we have $1 million of expenses, both for operating and reserves. How are we going to get $1 million? All right, we're going to need to do it through assessments. It's $1 million divided by X number of owners. That's what the annual assessment's going to be. Your payment schedule must be determined as well. Assessments for condos, I'm just going to spend just a quick moment on this. Sometimes I hear, well, Ed, we're a new board and the previous board was trying to keep the dues low. Our dues should have been higher and we need to raise them, but we're not allowed to raise them more than 15%, right? Because that's in the state statute. And I say, well, no, the only thing in the state statute is that if you raise your dues more than 15%, the members have the ability to propose an alternative budget. That's the only thing. It's not that you're prevented from doing that. Now, you do need to look at your governing documents. Sometimes poor drafting, in my opinion, from developers, they may say that the budget, the assessments may not increase more than 5 or 10% each year. And what they do is they do that as a way to get people to buy in the community so they can sell off their units or their parcels. And they want to show them that, hey, your dues aren't going to skyrocket. I prevented the association from doing that. So you do need to be mindful of that and whether or not you need membership approval to change that or not. And if you can't get membership approval, that makes some tough decisions and you need to talk with your manager and legal counsel about it. The other thing is collection of assessments. The manner of collection is stated in the bylaws or in your declaration. Must be less frequently than quarterly for condos. For HOAs, you actually have the ability to have an annual assessment, for example. And in certain instances for condos, you can accelerate assessments for delinquency. So that means if somebody, if they're a habitual delinquent owner and you get into February or March, if your documents provided and you provide the appropriate notice, you can actually tell them that you're accelerating the assessments that are due for the remainder of the year and you're calling those due. And if they don't pay them, they can go through collections, they can bear interest and everything. So take a look at that from a collection standpoint. Managing delinquencies, you really want to establish a collection policy. I teach a 1-hour course. Some of you have attended this on collection strategies. I'm not going to spend all that time on this right now. The main thing is that it helps you as a board understand, okay, we're going to allow a certain number of notices be sent out before a late fee is charged, and then before it gets to a stage where we have to record a claim of lien. A claim of lien is the instrument that you record in the public records that shows that the association has an interest in the property because of unpaid assessments. That's what places it out. It gets you in the priority standpoint and makes people aware if there's a title search being done, even though you still have to pay regardless of a claim of liens recorded. But you want to make sure that you have a policy in place that says, all right, after 30 days, we'll send a reminder notice. If it's not paid within another 30 days and the late fee's charged, or maybe it's earlier than that, and then if it gets to be 90 days from the oldest assessment, then we're going to send what's called an intent to lien letter. And there's a statutory requirement to send that before you can record the claim of lien. The nice thing about having the collection policy is that it helps your management company, if you use one, which probably 95% of you do, that they know that once an account reaches a certain phase, they don't need to wait for your next board meeting to get approval to proceed with the next steps. They know that the board has already established this policy. So I'd really recommend that you do this. I can work with you on it. We've helped draft these for our communities that we work with, and it makes sure that it's applied fairly and equitably to all owners. It takes a little bit of the decision-making out of you too as a board. Maybe if you didn't have this, you might have a neighbor that says, hey, can you guys give me a break? I just lost my job, And again, if somebody lost their job, I think there should be some consideration done, but it should be done uniformly. But it helps you say, hey, this is what our policy is, and we need to treat everybody equally on this. The other thing too is you want to use your statutory remedies. So you have the ability to restrict amenity use if people aren't paying their dues. Now that may be harder in practice than others, but if you have the ability to turn off key fobs, for example, or to go to the pool or to the clubhouse, that may be a remedy. You do have to go through the appropriate notice for it, which you have to vote on it at a board meeting and then send them notice when it's going to take effect. So it's not like it's an automatic, once they hit 90 days, you turn off everything. You still have to vote on it as a board. Same thing with suspension of voting rights. You can do that. That also has to be done at a notice board meeting and send them notice for it. You can also apply rent. If they're delinquent in rent, you can send a notice out to the tenant, require the tenant to pay rent directly to the association to offset the delinquency. Now, all of this is being provided as kind of a broad overview. You do need to talk with your manager and your attorney as to what the specific requirements are, but this is like a broad discussion as to what some of the powers and authorities that you have as an association. I don't know if most of you use Twitter. I use Twitter as a news source, and when I see they have what's called a trending topics on Twitter, and you can see what's the discussion item of the day, and it'll be 10 items in the US, for example. And when I see HOA trending on Twitter, I take a big gulp and oh no, I wonder what people are talking about here. And it was a story about somebody that had a really overzealous HOA that was enforcing, 10 minutes after garbage came, you're supposed to go out and pick up your garbage bins, the stereotypical overly zealous board. And so there was a story on that. But somebody within that kind of discussion said, hey, I would never live in an HOA because did you know that if you don't pay your if you pay your mortgage but you don't pay your assessments, that the HOA can take your property? And as an HOA condo attorney, I wanted to reply back and say, yes, how else do you think that we make sure that we get paid? Otherwise, we're contracting with vendors. And if we don't have teeth to collect from our owners, guess what they're going to say? I don't really like the vendor that you use. I'm not going to pay my assessments, and you don't really have a good way to come after me for it. So that's the main thing. You see this and people don't understand it, but you do have strong lien rights as an association, and you need to make sure that you properly enforce it, because otherwise what happens is if some people stop paying, guess who pays for it? The rest of the people that are already paying their dues, and their dues go up because they're having to bear the burden for their other owners. So for renters, I'll just touch on this briefly. Just note that you can send a statutory notice to the tenant. They have to pay the rent directly, and that tenants are protected. They cannot be evicted by the landlord if they pay rent directly to the association. There's some protection in the statute. I'm always very nice to the tenants when they call our office, because we want them to feel comfortable knowing that they can pay the rent and not be evicted by the landlord. And because if they pay rent, that's going to go a long way towards satisfying the delinquency for everyone. The other thing I have in here, this is just for condos, but you have the ability, if the unit is abandoned, and there's a certain statutory provision to determine if it's been abandoned, if it's in foreclosure or not, but you could go in to make necessary repairs, turn on utilities, or otherwise maintain, preserve, and protect the unit and the adjoining common elements. You can also obtain a receiver to lease an abandoned unit and then use the rental income to offset costs and expenses incurred and for the unpaid assessments and associated costs. So for our condos in here that are listening, and if you start seeing abandoned units that are in that there's a delinquency, you have other tools available to you, and just talk with your attorney about it. We can help you out with it. All right, so what do you do with surplus funds? Surplus, I mean, it's a good decision to have, or a good problem to have, I should say. Includes all excess monies retained by the association after deducting expenses. If not-for-profit corporation, which almost all of you are, I'm sure, and a surplus is not from a special assessment, the funds cannot be returned to owners. So what you do is it's credited towards the next year's budget, or it's allocated to the reserve account. The latter is what most people usually do. Instead of kind of having maybe it's an unanticipated surplus that you have, but that it's not, you don't think it's going to repeat the next year. Most associations don't like having the surplus as a credit towards assessments because it's an artificial dip in assessments that then go back. People don't like lowering assessments and then raising them the next year. So what associations usually find a way to do is either create a new reserve account or more fully fund their existing reserve accounts so that their operating expenses and they keep their assessments the same, if that makes sense. A special assessment surplus, though, if you have a special assessment, let's say you have a project and you're going to assess everybody $3,000, but you really only needed $2,500 from each owner, you can return the $500 difference to them, or you can do the same thing as a credit towards future assessments there. All right, I think I see, you can hold on just a second here. Somebody had a question is, there's an abandoned house in my neighborhood. Are there any provisions about the association being able to rent it out similar to its condo association? That's a good question from Tim. There's nothing in the statute that allows you to do it, but as an association, you have the ability to foreclose on the home. And typically a lien foreclosure can go quicker than a condo, a mortgage foreclosure, for example. And so the best way to do it is ultimately is to foreclose, take title to it, and then start renting out the property there. Dan asked a question, is there a recourse against the architect/developer for failure to provide a means of reasonable maintenance of a building? That's a tough question to answer. A means of reasonable maintenance, like if it makes it hard for you to go in and maintain it, whether or not that's a defect, that could be a potential claim for a construction defect issue. You have to show the actual damage, the actual cost amount, as opposed to it being something where they've made it harder for you to undertake maintenance. I think it would depend on what the hardship is that the association's facing and if there's a viable claim there or not. All right. All right, so reserves for condos, and then we'll touch on this for HOAs as well. The purpose of reserves is for major repairs and replacements. For other purposes, you cannot, one of the things is once you have a reserve account, you cannot use those funds for other purposes. You have to use them for their intended purpose. Otherwise, you need to have a member vote. The funds must be separate from the other operating funds. So the required reserve, this is per statute for condos. You have to have a roof reserve, a pavement reserve, a painting reserve, and any other item for which the deferred maintenance expense or the replacement cost exceeds $10,000. The budget must include a fully funded reserve schedule, and you can either have the pooling method versus the straight line method. Now I say this for condos, this also applies for HOAs in terms of they have to have a fully funded reserve schedule, and a pooling method versus straight line. So straight line is if you have, let's say you have 5 reserve components. You have your roof reserve, your pavement, your painting, and then let's say you have a pool, like a pool resurfacing or something like that. And so you have all those separately funded. If you ever need to pull money out, let's say your roof reserve has $200,000, but the actual cost is $250,000. When you have straight line funded reserves, you cannot pull money from those other reserve accounts. The $50,000 difference has to come from a special assessment, or you have to have a vote of the members to pull it out from the other reserve accounts. As opposed to if you have pooled reserves, you still are keeping track of all those components, and you have to continue to funding those pursuant to a funding formula. But in that scenario, if you have $250,000 project for the roof, but you had only really earmarked $200,000 for it, as long as you have enough money in reserves, you can pull that money out without having to have a vote of the membership. So it provides much more flexibility. So for HOAs, the budgets may include reserve accounts. If the reserves are established, then it's determined by a formula, must be maintained and funded, and it can be waived upon majority vote. If reserve accounts are not established, you have to have a disclosure requirement, and then funding limited to increases per the governing documents. So the main thing is that for an HOA, you have 3 ways that you can have reserves. If the developer established reserves in the initial budget, you're required to continue funding those reserves even after turnover. If the governing documents provide for reserves, or if the members vote to establish reserves. Once you have them though, then you have to fund them pursuant to a specific formula, which we'll talk about in a little bit. We talked about the funding method, straight line versus pooling. Reserve fund. So Florida law provides that once you have a reserve account, it must be funded to the fully funded level. So how do you determine if something's fully funded or not? Usually that's done by having a reserve study done. Well, you take a look at what the component is, what the asset is that you're reserving for, and they'll state, here's what the cost of it is, here's what the useful life is, here's what the remaining useful life is. And so in order to have the money that you'll need once you reach the remaining of the useful life, you need to keep funding this X amount per year. That means you're at a fully funded reserve. Now, what happens is some associations in the past, especially when you have a lot of delinquencies, they'll say, hey, we want to keep our reserve, we want to keep our assessments lower because we don't want to fully fund our reserves. You're allowed to do that, but only after the members vote on a reduced reserve budget. And so that's the main thing to note. If you don't get the appropriate membership approval, then the fully funded reserve account and budget has to go into effect. So that's the main thing to note for reserves. What's in the reserve schedule? All the required deferred maintenance and capital expenditure items. You have to have an estimate of the useful life, the remaining useful life, the estimate of the cost, estimate of the fund balance at the beginning of every year, and then the required funding for the budget year. So there are lots of companies that I've worked with that do reserve studies. They're professionals that you hire to go out. You usually do it depends on every 2 to 4 years typically. I have that here. There's actually no Florida law that requires it. I like to bring it up though. I had to do research on this, and that California has a law that you have to have a reserve study done every year. And I like to think that reserve analysts have a really good lobbyist out there to put that in there to give themselves more business. They did say that you have to do a more complete study every, I think, 3 years. And in the off years, it's more of a kind of a summary review, I guess would be the best way to put it. So really strongly recommend taking a look at when your last reserve study was done, and then going out and get a new one done, because you want to make sure that you want to be efficient with your funding, and you don't want to be either overfunding or underfunding. Because if you're overfunding, you're taking too much money from your members that you might not need to, and your dues are too high. If you're underfunding, you don't want to have an instance where you thought you had enough money, and all of a sudden then when you need to replace your roof, they say, hey, yeah, it's $250,000, but you guys have only funded this up to $150,000, so you're $100,000 short. You don't want to have that happen, so make sure that you have a reserve study done. That keeps you on the track to make sure that you're going to have enough money when you need it. All right, I'm just going to take a quick look at the questions here. If anything else came up from the financial side. Suzanne asks, if renters and owners choose not to obey HOA covenants, what can the board do? There's an enforcement process. I'm going to talk about that a little bit later on finding and suspension, but that's a good question. So I'm going to save that. David asks, is there a common element between upstairs units and downstairs in respect to plumbing leaks? It is my understanding there is not. Can you clarify? That's going to depend on your governing documents, but typically for condos, typically your unit's going to be from the paint in, from the drywall, paint, or finishing in, and then anything outside of that is going to be considered a common element. And then for plumbing leaks, I think the question might be is there anything that's affected from a common element standpoint? You could have, between the floors, if there's damage to the common elements in terms of the slab or anything else, that might require association to look at, but otherwise it may largely just affect the actual units themselves when water would come in. So it just depends on the nature of the leak and what was damaged or not, for David, for answering your question there. Brian says, for an HOA that maintains no assets in terms of common area amenities are maintained by CDD, is it reasonable to have a reserve fund that is 2.5 times larger than the annual operating budget? Seems to me that this is unnecessarily high. So I think, without knowing what is within the reserve components, you get into a tricky situation. My guess is that probably a lot of those reserves are like a rainy day fund or something like that. Reserves should usually be tied to some type of a specific asset that you're going to need to have money for as a replacement or as a deferred maintenance cost in the future. If you have a reserve that's really high, that's kind of a rainy day fund, you can get into an issue that the association is almost, I want to say, stockpiling too much, but it's really, you're meant to have enough money for what do we need for this year from an operating standpoint, and what money do we need to put aside for a future expense that we know about. I think in terms of an asset, one thing that I've seen some associations do is set aside money for their insurance premium. That may be something that is a larger cost that you want to fund for in the future. I mean, that may be something, but for the most part, you're talking about an actual physical asset that has a useful life, and how much is it going to cost to replace it. If you're going beyond that, it might be trying to have too much money available that might not have too many strings attached, that allows the association to maybe do some things that might other require membership approval. So, that's more of a summary answer for you, Brian, but I think we need to look at if they're authorized and if it's allowed in the governing documents or not. All right, so I'm going to get us through our last kind of big section, which is the official records, and this one should go a little bit quicker. The main thing is record maintenance. The official records of the association are open to inspection by any association member or authorized representative, and at reasonable times. The right to inspect includes the right to make copies at a reasonable expense. The official records of the association shall be maintained within the state. Records shall be made available to owners within 10 working days of receiving a written request sent to the board or the designee. The association is not responsible for the use or misuse of the information provided. So the main thing here is that, and I'll talk about what's considered an official record, but by default, the official records are open for inspection by the members. They have the opportunity to inspect within 10 business days of the association receiving a request to inspect, and that the association is not responsible for what they do with those records. So you can't, I've had this question come up, you can't have an association say, we know why they're asking for this. They're going to try to embarrass their neighbor because of X, Y, and Z, and so we're not going to allow them that because that might be unlawful for what they plan on doing with it. We can't prevent them from obtaining access to the records, and if we're worried about what the owner might do that against whom the records are being used, I guess, we can point back and say, hey, we had to provide them and we're not responsible for the use or misuse of the records. So that's one thing to keep in mind. So these are the records that need to be maintained. For condo associations, they changed the statute to say that these items must be permanently maintained, and for HOAs, it's 7 years. Copies of the plans, permits, warranties, and other items provided by the developer, a copy of the recorded declaration, bylaws, articles, rules, and amendments, the minute book, and then the accounting record. So that's permanently maintained for condos. It's 7 years for HOAs. I think that for HOAs that eventually they're going to have the same requirement as well. I've seen that in earlier drafts of bills that haven't passed where they've discussed potentially expanding on it like they have for condos. Associations must maintain for at least 7 years the current roster and mailing addresses, voting certifications, current insurance policies, current copy of the management agreement, lease, and other contracts, bills of sale or transfer of property owned by the association, and then this is the real catch-all, all other written records related to operation of the association. That's really the catch-all document that maybe if it doesn't fit specifically within here, if you have it, you need to make it available. For condos, there's some specific differences. The ballots, sign-in sheets, and voting proxies have to be maintained for 1 year from the date of the election. Presumably for HOAs, that's 7 years because it's a written record regarding operation of the association. All rental records is applicable. Copy of the current question and answer sheet is provided in the statute, and a copy of the inspection report is provided in the statute. As of July of 18, the association must keep electronic records related to voting. That's also included as part of the official records. This is also for condos. If you have an association of 150 units or more, and if I normally I do this, I'm in front of you, I'd ask you to raise your hands. I'd like to see how many condo associations there are that are like this. You have to have a website as of January of 2019. I'm not going to read through all of this, but this contains all of the documents that have to be made available on the website. Again, for co-ops and for HOAs, I could see this being a requirement in the future for larger communities like that, but for now, it's only for condos. All right, the records that aren't accessible, any record that's protected by the attorney-client privilege, information obtained in connection with the sale or other transfer of a unit, personnel records, medical records, electronic security passwords, software and operating system access information. Other records that aren't accessible, any social security numbers, driver's license numbers, credit card numbers, email addresses, telephone numbers, fax numbers, all these things that you may have, but if they're identifying personal information, that's not accessible to other owners. Although owners can consent in writing to allow the disclosure of their protected contact information. Contact information which requires no written consent for disclosure includes the name, the unit number, or the property, the property address, the mailing address, and any email or fax number provided to fulfill the notice requirements. And then on the next slide, they talk about that the statutes will clarify that all telephone numbers may be included in a directory, although an owner may choose to opt out, and whereas emails, you can only put them if they opt in. So the default is that if you have a telephone number for an owner, you can include it in the directory, but the owner can opt out. But for an email to be used, you have to get their specific consent before you can use it in a directory or as an official record. So for inspection, the official records of the association are open to inspection by any member and an authorized representative. The question is, what's an authorized representative? That's not clearly defined. If they ask for, their spouse to attend, maybe the spouse isn't on the deed, but they say, my spouse is going to be attending to inspect the official records, or my attorney is going to be attending. I usually err on the side of allowing it. It just depends. There's no clear answer as to what an authorized representative is. The association must respond to a records inspection request within 10 business days. We talked about that. There's actually teeth to this. If you don't make them available within 10 business days, then there's a rebuttable presumption that you've willfully disregarded the statute, and that you can be fined $50 a day for 10 consecutive days, so up to $500. But you can actually, the owner can prove damages greater than that amount. So there is teeth to this. In other words, you need to make them available within 10 business days. The association may comply with the inspection requirement by having a copy of the official records available for inspection on the condominium or association property, or offering the option to make the records available electronically via the internet or on a computer screen and printed upon request. And again, the association is not responsible for the use or misuse of information provided to a member or the authorized representative pursuant to the compliance requirements. All right, so that's what we have for official records. I'm going to go through some legal updates. I've kind of peppered them through, but I'm going to talk about some. Really for 2020, I'm just going to talk briefly about emotional support animals. The main thing to note about this is that there's a new Florida statute that was added to the Florida's Fair Housing Act. It heavily borrows from the Federal Fair Housing Act. It states that it's unlawful to discriminate in the provision of housing to a person with a disability or disability-related need for, or who has at any time obtains an emotional support animal, and they define what an emotional support animal is. Documentation may not be prepared by a healthcare, practitioner whose exclusive service is to prepare documentation in exchange for a fee. So there is actually, the nice thing about this is that it gives us a little bit more teeth. Like if you see that this documentation is provided by somebody that's advertising on the internet, that it's basically their business to give letters for emotional support animals, you may be able to object and say that we're not going to treat this as a valid request for an accommodation. There's a requirement that if the healthcare practitioner is out of state, they must have provided an in-person care or services on at least one occasion. That again prevents somebody, I've seen somebody in LA that is saying, hey, I'll do a quick telephone consultation with you, and I'll state that you have a disability that needs an emotional support animal, and then they'll send the letter out. So this, again, it provides a little bit more teeth for associations that are dealing with this emotional support animal request. The statute uses the word landlord. I put association in question mark. May also require proof of compliance with state and local licensing and vaccination requirements. And there are criminal penalties if for false or fraudulent proof of need for an emotional support animal. It's a second-degree misdemeanor. Now, proving it is difficult, but there at least is teeth for it. So communities with pet restrictions are strongly encouraged to adopt procedures for requesting accommodation in form of an emotional support animal. Again, it's kind of like when I talked about the rules and the reasonable rules regarding talking at a meeting or tape recording. You'd rather have those in place in advance before it becomes an issue, so it doesn't seem like you're making them up on the spot and treating people differently. And the main thing to remember when you're dealing with, as tough as it is sometimes, is remember that a pet and a proper support animal are not the same thing. Think of as a proper emotional support animal as somebody that really needs it. They have a disability and allows them to use the unit or the property in the same manner as somebody that doesn't have a disability. It's like if they requested a ramp because they're handicapped and they have a wheelchair that they need a ramp. Think of the support animal as the same way as another type of accommodation. If you can do that, it helps you, but I know that there's a lot of frustration here because people are abusing it by saying that their support animal needs a support animal, which needs a support animal. So I think that the change in the statute and adding it to the Florida statutes gives us a little bit more teeth in terms of fighting back for any requests, but still remember that it's an uphill battle in terms of evaluating these and whether or not you should grant these emotional support animal requests. Some additional updates from this year: law enforcement vehicles. This Senate bill included a provision which precluded an association or condo from prohibiting a law enforcement officer from parking his or her assigned law enforcement vehicle in certain areas. I think common sense would dictate if you see a law enforcement vehicle that's being parked on the street, cut them some slack. Now, I do know you probably have some owners that may be officers that may be parking their vehicles. So we just need to be mindful of that. If they're on duty or not. If you have a question about it and how that a bill may affect your community because you have parking on the street issues, just let your manager and really your attorney know. The other thing is regarding fireworks. The Senate bill allows, and you all may be aware of it because of this past 4th of July, you're allowed to have fireworks on designated holidays like New Year's, Independence Day, and New Year's Eve, but it doesn't supersede any prohibition. So just, if you have a prohibition in your documents against the use of fireworks, that's still going to be upheld. This statute doesn't say that you now have to allow them in community associations. That's not the case. So that's one thing that affects associations that I wanted to let you guys know about. All right, so there was a question before about finding and suspension. I'm going to kind of give an overview on the finding process, which is that if you have a violation of your documents, you should have an enforcement process, a policy in place, kind of like your collection policy, where they'll receive certain notices before, it's kind of heightened in terms of what the next action is going to take. And so you have the ability to fine. Now, what happens is that the board imposes the fine, but that the fine cannot be collected until it's approved by a committee made up of 3 or more people. They have to be members that aren't board members, officers, or employees, and they cannot be spouse, parent, child, brother, or sister of an officer, board member, or an employee of the association. And so that's kind of the final committee. I don't really like calling them an appeal committee. I guess you could call them that, but really it's because the board's already imposed it, but they're the ones that get to approve whether or not what the board did was proper. Whereas an appeal committee means like, it almost implies that if you don't ask for it, then it's deemed to be effective. In this case though, the fine is not effective until that committee approves it. Whether or not that owner ever does anything, you still have to approve it at a committee hearing. So you have that process, and that committee hearing has to take place at least 14 days after the notice has been provided to them, notifying the owner or the violating party of the fine. So the committee meeting moves forward, the committee meets, they approve the fine, and then that fine is due within 5 days after the due date. So, and then if they don't pay it, then you can go forward with collection actions and so on. If you don't have this fining committee, that doesn't mean you aren't able to enforce your covenants. It just means that you may have to go through another route of sending notices, and eventually you get your attorney involved. And then if you're in an HOA, you go through what's called pre-suit mediation. If you're in a condo, you probably have to go through arbitration to enforce your covenants. So the thing about fining though is that once you get the process going, you might be able to do it and keep the expense of an attorney out of it because you have a a well-oiled machine in terms of enforcement and fines, that if handled properly, owners, hey, I don't want to get fined for this, I'll correct this, and that's how things are taken care of. If you don't have enough people to volunteer for this committee, it doesn't mean you don't get to enforce your documents. It just means that you're probably going to need to involve your manager and your attorney more, and that leads to more expense, and it kind of escalates it quicker to more of a legal standing than it otherwise might be if you go through the fining process. Condominium updates, this is really small print, especially depending on how you're looking at this. The main thing is that there's been a lot of discussion on this. There's a material alteration provision in the Condo Act that says that unless otherwise provided in the documents, any material alteration must be approved by 75% of the membership. And a material alteration is anything that really like perceptively changes what the community looks like. There's a case on point on this. You know, if you repaint your buildings from, let's say, brown to I'm going to say yellow, but that's still close enough. I don't know, pink to brown, for example, or something like that, where it's a pretty big difference, pink to green. Okay, how about that? Even if you had to repaint, if you're changing the color of it, that's likely deemed an alteration that requires membership approval. Or if you're going to be taking down some type of capital improvement or putting in a capital improvement, that's an alteration. You need to have membership approval. This statute says that vote must take place prior to the work beginning. You can't do it and wait later for somebody to challenge you on it. So that was one change to the statute. Electric vehicles, they added in a provision for condos that basically say that, yes, there's a material alteration provision in the statute, but if you want to have, if you have a defined space, or if you want to request that you have an assigned space with an electric vehicle charging station, normally that charging station would be an alteration that requires member approval. This allows you to do it by board vote, but there's a lot of hoops to jump through. You basically have to name the association as additional insured. You have to have architectural standards complied with, comply with safety requirements, engage the services of a registered electrical contractor, provide a certificate of insurance, listing the association as additional insured, reimburse the association for the actual cost. So again, this all is basically a way to say that there's a way to put an electric vehicle charging station without having to go through the perhaps impossible threshold of getting 75% membership approval or whatever your documents may require. But there are a lot of hoops for the owner to jump through. So interesting to see. I think you see this a lot in South Florida or places where parking is at a premium and you've got a parking garage and people have electric vehicles that they want to have charging stations. This is a way to now do that without having to go through the member vote. Some HOA updates. These are from, all these what I'm talking about now after the emotional support animal and the police parking and the fireworks are from 2 years ago. Some updates: when you're amending your governing documents, you need to make sure that any changes are underlined, any additions are underlined, any removals are in strike through. We've already done that, but that's now a requirement. If you're sending out, this is kind of a big one that if you're an HOA, you need to talk to your management company, is that if you're sending out any required notice to the membership under Chapter 720.306, which is anything regarding membership meetings, you have to mail or deliver it to the parcel owner's mailing address on the property appraiser's website if that address is different from what the official, what their association address is. So this now places an obligation on the association to check what address they have and see if there's an additional one, even if that owner didn't update you with it. So it creates a proactive requirement on it. So be mindful of that and make sure that you're doing that so that somebody can't challenge the results of some type of vote because they said that they didn't receive notice because you didn't send it to their address on the property appraiser website. The other thing that was changed is that assessment payments, any partial payments applied per 720.3085. So that's where if somebody's delinquent and let's say they owe $1,000 and they make a $500 payment, but they try being cute and putting on there that payment in full and you accept that, they can't claim that now the account's been resolved. The statute was amended to say that regardless of whatever restrictive notation was included on payment, it's still applied as a partial payment, which means that it goes towards late fees, interest, and attorney's fees first before it goes to the assessment. So that created that closed off some potential issues that we saw where people were trying to get around, you know, and establish a situation where they got out of paying, having to pay their full dues because they put payment in full on it. The last thing is I'm going to talk about is the Marketable Record Title Act, or also referred to as MARTA. Just as a brief overview, what this is, it really only affects HOAs. It could affect co-ops. I'd have to take a look at it because really what it does is it affects covenants that are recorded that really aren't reflected whenever property is transferred from one owner to the next in the legal description. You have that in for condo associations because your condo declaration is always referenced in the legal description for the condo unit whenever a unit's sold. So really the Marketable Record Title Act states that your covenants can expire if they're not preserved within 30 years. And so what the statute change was, they also added a property owners association, which really could be, the intent of this is a non-residential property owners association can go through the Marketable Record Title Act and preserve the covenants. It simplifies the procedure for the renewal of covenants and the restrictions. I talked about that. That's done by board vote. There's an alternative procedure on MARTA preservation. We're talking about that in terms of board vote. And then, but this is the kicker though. And this is where the legislature really thought that they were doing something to try to protect members by not allowing the covenants to expire. It creates an obligation for the association to annually consider preservation. The problem with it is that it didn't distinguish the age of the association that had to comply with this. So if you live in a brand new HOA and that's only 2 years old, you're technically required to annually consider preservation. I would have liked them to have seen, hey, for any community whose original covenants and restrictions were recorded at least 20 years, previously that have not otherwise been preserved, they're required to annually consider preservation. Something like that, where once you're getting close to that 30-year requirement. So one thing is to note for HOAs, you are required to do that. You're not allowed to do it at the organizational meeting, which is done right after the member meeting. You have to do it at the first meeting after the organizational meeting. And I've provided canned language for that, which is basically reflected in the minutes where the board said, by law, we're required to discuss preservation of our documents. We will be taking no action at this time because of the age of our community, something along those lines. And that should protect your community and show that you comply with the statute. All right, so in summary, and once I'm done with this, I'll make sure to answer our questions here. Board members have the fiduciary obligation to set aside their personal agenda and put the association first. You want to stay focused on the job at hand, be familiar with your governing documents, know your duties and perform them competently, set goals and establish values, and then I like to include this last, obtain the necessary education. You're here today, you could have, instead of taking this class, and maybe you're thinking like, well, shoot, if I would have known this, I would have done this. You can sign off on a document that basically says, I agree to abide by my governing documents and the laws governing, condos and HOAs or what have you. And that would suffice. But the fact that you're here today and you took this course and you sat through, we're here for almost more than 2 hours, that shows that you have a commitment to obtaining education as a board member, whether a new one or an ongoing board member. And so I think it's great for you to do that. For my firm, what we do, and if you look at our YouTube page, we continue to teach different courses on specific topics. We'd love for you to have those. And if you'd like to be notified of those in the future, please email me. I'm going to put my email address up here. But aside from that, I have my contact information up here. I'm just going to go back and I'm going to leave this up just so you have it and you have our website. But I'm going to go back to some of the questions that we have here. All right. Steve had asked, just generally, will the slides be shared via link or email? Yeah, if you can email me, if you'd like a copy of the PowerPoint, I'm happy to provide those to you, and my email address is right here. Okay, one question from Dan is saying that they've had housekeeping employees that have tested positive. We have other employees that are demanding that they get tested immediately. We're thinking of paying that fee of $150 for an immediate test. If we do that, can it be construed that we will also pay for their potential medical bills, which we do not want to pay? I think there's a difference between maybe asking and saying, hey, I'm insisting on you taking this test, as opposed to paying for medical bills. I could justify the paying for the test up front. I think, there should be some further considerations of whether or not that's a proper common expense. I think there's some merit to it. I think it would require further action, but I'm not too worried though, even if you were to do that, that now you will also be paying their medical bills. I don't think that one implies the other there. Kathy wonders, does it really cost thousands of dollars to edit or amend our bylaws and refile with the state of, we've been told? It just depends on how many amendments you have. If you're doing like a complete restatement of your documents where you're amending a lot of things and you're putting a new set of documents in front of your members, that typically does, for our firm and most other law firms that you talk to, there's a lot of work that goes into it between drafting the language appropriately, making sure to analyze what the statutes require. There's a lot of work that goes into it, so it's not uncommon for that. But in terms of maybe a single amendment or something, you can certainly do that for much less cost. It just depends on the nature of the amendments there. All right. Shannon asks if a unit owner who serves on the board stops serving at the end of their term, but then at the next election their spouse is elected, how does the 8-year term limit apply? It's a good question. The 8-year term limit only applies to that specific member. It doesn't mean that their spouse is prohibited from running. So that spouse would be able to run. And the guidance that we received so far is that 8-year term limit for condos only applies from really 8 years going forward from 2018. Now that's subject to interpretation. Somebody may challenge that, but that's the guidance that we received. But if you had a spouse running, that wouldn't prevent them, even if it's a husband and wife. So that's a good question, though. So Alex had a question about board member terms. Our terms are 3 years or 36 months. Director A serves for 30 months of a 36-month term and resigns. Let's see. Director B serves for 12 months of 36, so they resign and there's 2 years left basically. The remaining director is assigned the B term without replacing the A director. Is this process correct? So that really, what it comes down to is the discretion of the board to fill vacancies. I could see the board in that instance saying, we're gonna appoint somebody for this longer remaining term versus only the shorter term because the election's coming up. It's really at the discretion of the board, unless the documents require the members to approve that. So you do need to look at what your governing documents provide, but generally it's the board that has the discretion, and whatever position they're filling, that person is filling the remainder of that term. Gustavo asked if email is acceptable as electronic voting. No, there's an actual process and a procedure where a resolution has to be adopted, and there are certain software requirements. So email itself is not an acceptable form. You have to go through, and there's a bunch of vendors that do this, but it's not just email. You have to go through a more specific process and protocols in place to make sure it's a valid electronic voting process. I think I answered Suzanne's question before about if renters and owners do choose to not to obey the HOA covenants, what can the board do? And I talked about the covenant enforcement process. Can the records be redacted to avoid homeowners from targeting neighbors? No, you really have to keep the records as they are. You can't do that from targeting neighbors. That's why it has the provision of the HOA is not responsible, or the condo is not responsible for the use or misuse of these documents. Joseph said, very helpful session. Thank you. Well, you're welcome, Joseph. I hope you're still on, but if you're not, we appreciate you attending here. Mary Ann said, in regards to a records request, does a unit owner have a right to ask to view a lease of another unit with that lease containing a background check? So that's a good question for Mary Ann. So that would be, there's a provision on there that any documents obtained in regards to the sale or the lease of a property is part of the official records that are open for inspection. So that's a good question, that you would keep those documents separate and that a neighbor is not able to look at that. A board member is able to look at it, and that's part of maybe the approval or the notification process, but then that would not be open for inspection by a neighboring homeowner, because that's a record not open for inspection. Gustavo asks, guidelines for capital improvements in HOAs, members, it says notice and approval. So that's going to depend on, it's going to be governing document specific. There is no provision in the statute for HOAs regarding a minimum threshold or a default threshold for approving capital improvements. It's going to be as provided for in your governing documents. The question is, with regards to noticing members for violations, overdue dues, etc., can email be used, or does it always have to be done by regular certified mail? So you might be able to send a kind of an informal late notice, but there is a statutory requirement to send by regular mail and certified mail for any intent to lien letter, and then for the subsequent notice of lien and intent to foreclose. So there are certain statutory notices that have to go out regular and certified mail. There are other ways that you can send it informally, but you'd prefer to have it by certified mail just to show that they've signed off on it, and by regular mail so that if it doesn't bounce back, you know that it's been delivered. But if it's more of an informal thing and they've given their, especially if they've given their email address for notice requirements, you can argue that that was And if the email didn't bounce, for example, and you've used it before, that would be a way to deliver an informal. But just note that certain things require statutory written notice, and you just need to make sure that you do that when the situation warrants it. And I think that was the next question too, or maybe that was another repeat question about via email rather than through US mail. So this is the thing, and this kind of touched on a larger part, which is that owners can consent to receive official notice by email. It's not for everything in the state statute that requires official notice, but it's for a lot of things. But they do have to sign off on a written consent. It's not enough that you just happen to have their emails, and for all the people that you happen to have their emails, and now you send everything by email instead of by regular mail. What I recommend, and what some associations do, is to encourage this, and it helps save on cost because now you're eliminating some of your mailings, is when you have a board meeting or a member meeting, or you always, like as part of your notice, just blast out and say, hey, we really encourage you, if you haven't done so already, and if you'd like to receive email instead of by regular mail, it helps save on our mailing costs, please fill out this form and send it back to us. That's what I'd recommend doing. Glenda asks about preservation of documents. What's the procedure? It's actually a pretty nice procedure right now in that it's done by board vote. And actually the statute has changed recently to state that if you've amended your governing documents and if you've done so in a specific manner, then an amendment to your documents may actually serve as preservation. So the main thing is that if you're coming up on 30 years from when your covenants were originally recorded, and that's kind of a generic conservative answer, it's not the exact answer, there's a little more nuance to it. Just double check and make sure that you go through the preservation process. I know when our firm does it, just to give you a very general answer, it's less than $1,000 for our firm to help with the form and the notice requirements. So you just don't want to let it go by, because once you go past the 30 years, then it's called revitalization, and that requires a whole member vote, and that's when you get into the thousands of dollars for the costs. So that's why it's important to stay on top of it. David says, thank you, very informative. Well, thank you again, I appreciate it. Let's see here. What happens if nobody volunteers to be a board member? Can a management company be the board if nobody volunteers? You know, typically though, your board is required to be made up of members. So what happens is if you don't have enough volunteers, you really got to press the members to try to get somebody to volunteer themselves. A member of the association can then go to the state to ask for a receiver to be appointed. You don't really want that to happen, because then the receiver is taking money out of your already operating budget to pay themselves. So you really want to press on it that you need to have people for this thing to run. You got to have people run for the board. So yeah, it's a tough situation, but it is something you really want to go out and try to get members to volunteer. Yeah, Joseph, if you'd like a copy of the presentation, if you still see the slides up here, email me on my email address. I'll be happy to email you a copy of it. Thank you, Dale, for attending too. How would you recommend enforcing the removal of a commercial vehicle from the neighborhood? Notices have been sent. Okay, so from that standpoint, it depends on where it's parked. If it's parked on private property, it's really difficult, and it's tough to get involved with anything with towing there. If it's on association-owned streets and you've gone through the towing notice, you might be able to tow it. But for the most part, what you're doing is you're going to send notice, and then if you're an HOA, you have to go through pre-suit mediation requirements and go through mediation. If you're in a condo that's parking and they're parking commercial vehicles in the condo spaces, you have to go through arbitration and get an order from the arbitrator requiring them to remove it. So that's the process, and it necessarily involves getting your attorney involved on that. All right, well, that's all the questions that we have here. Thank you all for attending. I see some people that have raised their hands, and thank you all for doing so. And if you have any questions, or if there's anything else that we can do, like I said, we have 8 attorneys in our law firm. We only pretty much represent condominiums and HOAs. If you don't work with us, we'd be happy to work with you. Just send me an email and I can let you know how we can work that out. And again, email me if you'd like a copy of it, but otherwise, we will be emailing you next week with a copy of your certificates so that you can keep those in your official records. All right. All right, everyone. Thanks. Have a good day. Have a good weekend, and everybody stay safe out there. Thanks a lot.